Good morning, good morning, good morning, good morning, amazing Leonard. It's so good to be here with you. It's Wednesday. It's July 15th. It's right in the part of the summer where it feels like August is going to be here before you can even blink. And I'm trying not to count down to DCI finals too much, but it is the week of, the middle point of the season. It's San Antonio week. There is a lot going on. There's a lot going on in law. There's a lot going on in life. I have to give you fair warning. There is work going on at my house. I have been promised that my power will not be going out and that nothing should be happening to my internet. However, if there are any foibles, if there are any rough patches, have the app. We'll be back. It's going to be fine. It's not you. It's probably not you. It's probably me. It's probably me. So with that, we have a lot to cover today. I'm going to let you know what we're covering, what we're not covering, and when we will get to what we're not covering. So I know we're not going to get to everything today, which is really hard for me to be like, we're not going to get to everything today, but I just physically actually cannot. And it's going to be fine. It's going to be fine. We're here. We're going to do all the things. Law nerds, we're going to run the intro. We're going to do what we're covering today. We're going to do a bit of a road so far to get us into what we're covering today. We got some filings. We got some court. Apparently we've got some craziness. I've got Cavaliers show music stuck in my brain. And I got to see my kiddo, and I've got a little bit of a chat with the law nerds that I would like to have, and I'm going to try not to get all emo about it. So we're going to roll the intro. I'm sure all the mods are like, Emily, what are we doing? Don't worry. It's all good. It's good. We're going to roll the intro. Let me know where you're coming in from, what you're drinking. I've got coffee. Is it too hot for hot coffee? Probably, but I'm going to call it glow. We're glowing. It's fine. It's all fine. The weather's fine. It's all fine. It's all fine. It's all fine. Emily, do you know what day it is? No, I'm completely discombobulated. Was supposed to be home on Sunday, got home on Monday, still think it's like Tuesday. It's actually Wednesday. I get on a plane tomorrow. It's all fine. It's fine. It's going to be fine. Let's go, law nerds. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Okay, so law nerds. First, Ash, I saw your ask in the chat. I did get to give Travis a hug. I gave Travis many, 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 many hugs. All of the hugs. There is not enough time sometimes to hold. Oh gosh, I'm going to get all emo. There is not always enough time to hold the people that you love, but it's all good. So it was absolutely incredible to get to go see him. I am a little overwhelmed, as you can tell. We've had some grief that we're dealing with, but that is one of the facets of life. But it's also why I was like, I'm getting on a plane. I'm going to go hug my kiddo. It's going to be amazing. So I wanted to say, because the other thing that made me just completely overwhelmed with emotion is that, and I'm going to try to not make all of you cry. We are okay. It is what it is. I'm going to try not to make you all cry, but I'm going to cry because y'all make me cry in a good way. We're going to go to the good crying. Law nerds. My friend Spidey, who runs an incredible channel over here on YouTube and does really human analysis. Like, he looks at what humans are saying and how they're saying it and what they're doing and breaks that all down with an incredible amount of heart, compassion, education, and knowledge, and then experience. He is someone that I absolutely enjoy interacting with. And he had posted on his community tab that he was going to be reaching out and asking me about the Tyler Robinson preliminary hearing. And I saw the comments in there because he's like, Emily, you have to come see the comments. I saw the comments in there. And so many of the law nerds were like, hey, I would love for this collab to happen. However, I know Emily's got kiddo stuff going on. I know she's super busy. I know she's not covering this video. y'all were so incredibly empathetic and kind in sharing what I had shared with y'all, that I had stuff going on with family, had a lot going on with kids, and had all kinds of stuff going on. And I was so incredibly touched and just so encouraged, because he and I, one of the things we talk about sometimes is how the internet writ large can be challenging, but that this community that I've built, that you've built, that we've built together is incredibly thoughtful, compassionate, mindful. And it was just such a beautiful reflection of how caring you guys are. I was so incredibly touched, and it really did just warm my heart. And the amount of care, and I can't thank you enough. So you guys, I was so incredibly touched by how just compassionate and kind you are in sharing that, like, because nobody was like, she's too busy. It was all like, hey, just so you know, she's got a lot going on. It was so compassionate. You guys are the best. Thank you. This community is so incredible. And I just wanted to take a minute to say thank you. I was so incredibly touched. It's been a rough couple weeks. We will talk about that down the road. Our immediate family is okay. It doesn't stop grief from hitting you sideways. But just, that's something that I don't want to dump on all of you because it's much, but also I need to process it before I can talk about it, which I appreciate how kind you all are. But also just to see that level of compassion and encouragement when I am having a tough week, I was just like, oh, the law nerds are so wonderful. So thank you. And then I did have a great conversation with Spidey, and he wanted to ask me about the law side, which is perfect. I'm like, I can tell you about a preliminary hearing. I can tell you about stuff that's being admitted in a preliminary hearing. What I can't do is do like 5 days of Nestor. I don't know. I don't know. I can't. I don't know what I would do. I just can't. That's what I can do. I cannot do days and days of prelim with Nestor at the moment. I don't have the bandwidth. But it was really lovely. And it was really nice, even in cases that I'm not always covering, to be able to share what I know. Because the amount of preliminary hearings that I've done in my career are innumerable. We're not talking hundreds of prelims, because there were times I was doing 10 to 15 prelims in a day sometimes, but it's so many. It's just a process that I'm so familiar with. And I was really happy to be able to share the legal side of that with him, what the evidence looks like there, and then let him share all of the other parts of his coverage there. I know there are many on the internet covering that case. I've gotten a lot of questions about it. I have not covered the law of that, but I know that Spidey has covered it. Lawyer has covered it. Andrea Burkhart's covered it. There's plenty of channels that are covering it. So with this, I feel like I can barely keep up with everything going on in Karen Reed, which is what we are going to be talking about today. But I just wanted to add that there are, and this is not for the law nerds, but for the internet at large, many people were calling that preliminary hearing a trial. It's not. It rubs me very much the wrong way. That the way it rubs all of you when I pronounce like where you're from the wrong way for like at least 2 months before I get it right, it's the same kind of thing. But there are so many, not lawyer run channels, but large media channels calling it a trial, and it's just not. And it's like, but it's not a trial. It's a preliminary hearing. No wonder everybody's confused. Stop calling it a trial. You call yourself an outlet that streams trials. This is not a trial. It's not a trial. It's a preliminary hearing. Preliminary hearings are just remember we talked about it being like a LaCroix of evidence. It's like a meh of evidence. It's like that might be orange flavored water. It might not. I'm not sure. It's a whiff. Is there just meh amount of evidence to show that person's likely to do that thing? And we'll add Spidey's channel to we'll add it to the description so you can go find his channel on the behavior arts. So we'll add that as well. But it's a Yes, a skosh. It is a meh. Did this person in custody most likely, are they connected enough to the thing that they're doing to hold them over for trial? It is not a finding of guilt. It is not always a testing of the veracity of the evidence. It is a testing of, is there evidence that leads you to believe that this person was in this place at this time and did this thing? That's it. It's meh. So I was happy to give some analysis to him. So he's got a video of that there. For those of you that don't know the deep lore, we'll talk about it another time. There's some deep lore. I enjoy when I get to have a conversation with other creators. Sometimes we go too long because life just gets busy. But life didn't get too busy to go see my kid, to go catch some live music. Look, call it what you want, but music that like hits you in your soul is just good for the soul. It doesn't matter that I, again, woefully miscalculated the levels of mosquitoes in Whitewater, Wisconsin. It does not matter. It does not matter. It's all good. The mosquito bites will heal. The memory remains. It will all be fine. It was a band mom fail. I will never, ever, ever. I solemnly swear that I will never forget multiple layers of bug spray again. Ever. Ever. But it's fine. But it's fine. But it's fine. I was attacked. They are different. Look, different, those mosquitoes. But it was beautiful being in Whitewater, Wisconsin. I got to go to the home show. We'll talk about that more in other content. I will share more band breaks with you guys after we're in San Antonio. Let's talk about what we're talking about today, shall we? Shall we? Let's talk about what we're talking about today. So let's give a quick road so far. All right, quick road so far. Today we are focused on the Karen Reed wrongful death case with a +1 sidecar of a hearing that is not from the Karen Reed wrongful death case. What we are not doing today, but we will come back to because it will wait and we are not going to have a ruling on it quickly, is the fleet of motions to dismiss. Oh, my nose is tickling me. Hold on. Hold on. All right. What we are not covering today is the fleet of motions to dismiss. They're not going to get ruled on swiftly. We have not gone over the motions. I would like to go over those motions with you. There are a lot of them because in the federal case with Karen Reed sues everybody for deprivation of rights, etc., there are motions to dismiss in that case. And then in the defamation case with the House defendants suing Karen Reed and Turtle Boy, there are motions to dismiss, anti-slap motions, etc. There's a lot of nuanced law in there. There is a lot to be discussed in those motions, and we have not yet gone over the filed motions. And one's a federal hearing, which we won't see, but one is a state level hearing that we will see, and we will cover those next week. But I want to go through all the motions with you so we have a foundation before we get to the lawyer arguments. So we look at what law is in play there, because anti-slap in Massachusetts is different than some of the anti-slaps we've covered. I covered this, I don't remember where, maybe in a podcast where we talked a little bit about the differences, but we will get there. The rulings aren't going to happen quickly, so we'll get there. No fear. Cavalier. We'll get there. Today, we have a fleet of rulings that happened before the two hearings that we are going to look at. So today we are going to go to the hearings first, or the rulings first, and then to the hearings. Some of them were on the same day, so I'm not sure if they got docketed before the hearing or after, but I'm going to cover the writings and then we're going to go to court because Judge G, sir, I don't understand how we've gotten to the legal equivalent of I know you are, but what am I? But the lawyers and Judge Gildea are just and I don't know. I don't know. I don't know what has happened. I don't know. This is the opposite of efficiency. Can we just get to efficiency? Nikki Crayons in the chat. Yes. Nikki Crayons in the chat said citing rubber v glue. Yes. Yes. And all of it is so inefficient. And I can't really fault the lawyers for playing to the judge that they have. We have used all the sports ball analogies in the past, but you play to the referee that you have. If the ref's not calling any fouls, you can actually see the gameplay shift. And so that's what's happening here. And it is going to continue to happen unless there is some consequence beyond the judge just being like, beep, 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 beep. It's a lot of judge talking and not a lot of judge action. And I think it's just fanning, the embers in this case and not really helping anything. So it's frustrating to me. I have not watched the hearing. I have not read all the filings. I have pulled the filings. I've seen the titles and I went, oh boy. So law nerds, thank you for no spoilers. Let me tell you what. I watched all of, I've rewatched my kiddo perform a number of times. I have watched some of the soccer/football or whatever you want to call it. I have tried to figure out why Erling Haaland was leaving a plane with a raccoon and like a whiskey bottle. There are other things I have been endeavoring to figure out in the world. I knew that I would figure this out with the law nerds today. So law nerds, thank you for no spoilers. I know that there are some of you, I'm sure, that have already seen all of the things we are going to cover today. Some of you have not, but thank you for no spoilers for me because the ADHD will like squirrel and sidetrack. And I appreciate you helping me because I want to go through this with you. So we have a bunch of motions and orders that happened before this hearing. Then we are going to the continuing motion to compel hearing from July 10th. That continuing motion to compel hearing was regarding Colin Albert. Remember, the lawyers needed to talk to him and they could only talk to him on Saturday. We've had 2 hearings about Colin Albert so far. This is number 3. So we are going to do that. We also then have, remember, the judge said, hey, lawyers, I would really like you to all fashion some type of discovery agreement. And I want you to like sidestep the protections that you have and make it more stringent. Shockingly, it seems that none of the lawyers took him up on that. And he said, if you don't file it by this day, I'm going to file one myself. So he filed one. We're going to look at that. And then all the lawyers responded to it. I do not, again, in this, I don't fault the lawyers for being like, there are discovery rules. Why would we make it easier for you to punish us? I'm not going to do that at all. So he filed, he went ahead and filed that. So I am going to go again in kind of date order. So we are going to do the things that came before the July 10th hearing, the July 10th hearing, and then what the court did after the July 10th hearing. Does that make sense? And then we are going to go to a hearing from July 13th regarding Karen Reed's cell phone. So that's what we're doing today. That is in a criminal case, but Karen Reed's lawyers are there arguing it. They are still fighting over the cell phone. So we are going to go take a look at that cell phone hearing. Sound good? All right. Everybody. Yeah. Ready? Are we ready? We're going to do the things. Before we jump into the Karen Reed emergency? That is an emergency. Where is it? This is our new emergency sound. It's an emergency. The emergency. I need more coffee. We're going to go to the triplet of filings with the Karen Reed emergency motion for reconsideration regarding all the Proctor stuff, and then Proctor's opposition, and then the reply, and then the court order. We're going to go to that first. But first, we are going to take a moment to thank Incogni for allowing EDB to make responsible choices on stream, like playing Papa Roach. We love this, and we love Incogni for it. And it's like my monthly opportunity to share with you the latest and greatest of this episode of How Your Information is Ending Up on the Internet Today. Thank you to Incogni. Lawnerd, I hope very much that you are not one of the 6.9 million individuals impacted by this latest breach of driver's license information. I know, it feels like every time we turn around, your personal data is just exposed everywhere. But today's sponsor, Incogni, helps take it back down off of the internet if it does get exposed. Incogni tracks down and removes your personal data from multiple sites, including online directories, all of those really annoying search sites, and even commercial databases. So with just 3 easy steps, you're up and running to start having your information protected and taken back down when it does get out on the internet. Plus, Incogni will go beyond that automated removal, and you can do custom removal through them. Plus, Incogni is the first and only personal data removal site that has been independently verified by Deloitte. Plus, there is a 30-day money-back guarantee, and you can cancel anytime. It's time to take back control of your personal information with Incogni. Lawnerd, if you haven't already checked out Incogni, now is the time. Use code EmilyDBaker at incogni.com/EmilyDBaker to get an exclusive 60% off an annual Incogni plan. That's right, 60% off an annual Incogni plan when you use code EmilyDBaker at incogni.com/EmilyDBaker. Thank you again to Incogni for sponsoring this video, allowing me to make responsible decisions and keeping my and my family's personal information safe and off the internet. Now let's get back to today's stream. Lawnerd, you know that I've worked with Nord since the very, very beginning of this channel, and I bring to you A, sponsors who make things easy, and B, sponsors who I work with and trust. And Incogni has been at the forefront of that with all of the other Nord products that I use and love. But it is so needed. It is so needed. So let's get into the court documents, shall we? All right. We are going to start with Karen Reed's emergency motion for reconsideration. The backstory on this, and I'm sure they'll put it in there too, is that Judge G held that wild July 1st, like, y'all gonna get into court hearing, and was like, someone leaked some information. And then Karen Reed's attorneys were like, can we be heard? And the court's like, I'm not coming back out onto the bench. And so they filed a motion to clarify the record, and the judge didn't like the way that they filed the motion to clarify the record. And then the court was like, you don't need to clarify an order. I didn't make any orders. But the judge did make an order. The judge stayed all the discovery as to Trooper Proctor, meaning no follow-ups on interrogatories, no part 2 of the deposition that was incomplete, no following up at all. So at that time, I said Karen Reed's lawyers might have done better with this judge to have led with clarifying, hey, Your Honor, we think that the stay is a really extreme remedy, and this remedy seems to only impact one party, us, and you don't know who leaked anything. And by the way, we have reason to believe nothing was leaked. It's just that the internet has information that didn't come from any of the lawyers. So given that new information, can you please allow us to continue with discovery? TikTok, there's a deadline in August. Thanks. But the court was just like, this is not what a motion to clarify the record is for. And so comes now Karen Reed's lawyer's second attempt to try to figure out what the judge really means by staying all the discovery as to former Trooper Michael Proctor. This was filed July 8th, 2026, because everybody's just filing everything. I don't know how these lawyers are doing anything else, like in life, because between this case, the federal case, and the defamation case, so much has been going on. And that doesn't even include the MSP Canton case. It really is a multiverse of litigation. I should swoop. Let's swoop. Swoop. Emergency motion for reconsideration of order delaying deposition of Michael Proctor. I mean, it seemed to stay all discovery. This has both a filing stamp and an electronic filing stamp. Emily, why do you point this out? Because I can't figure out the inconsistencies, and I figure if I keep saying it, this audience has the highest pattern recognition of any audience on the internet, bar none. And someday we will figure out the difference between when they digitally stamp it, when they file stamp it, when they don't do any of the stamping. We'll figure it out. If anyone can figure it out, it's us. We've got this. All right. Defendant Karen Reed respectfully requests that the court reconsider its June 29th order staying further discovery of Michael Proctor. The court stated on the record, it was like an order that wasn't an order that was an order. It was like, do you mean it, or do you not mean it? They say the court stated on the record that it stayed the second day of Proctor's deposition because an attorney with an appearance in this case had, quote, violated either the letter or the spirit of the rule. I think they said the rule. I think the court said the order or the ruling, but either way, violated either the spirit of the letter or the letter of the rule. I only remember this because we were like, what do you mean somebody violated the vibes? Like, excuse me, lawyers. You violated the vibes. How do you violate the vibes? How do you violate the vibes of the protective order? Huh? They go on to say the statement is incorrect. Y'all, they're just going to keep locking horns with this judge. I don't think they care. But we already know that this is going to make the judge prickly. First, they say the ex post that the court cited as the only evidence that its impoundment order had been violated was actually posted before, underline bold, Proctor's relevant June 8th, 2026 filing. Second, the information that the court claimed had been discovered by an attorney. I'm not going to yell this all in my bold voice. Underline bold, was already public as of June 6, 2026 at the latest, more than 2 days before the filing or impoundment order at issue. Right. And I think probably before then, because chat was asking me about it before then. Footnote 1. Footnote 1. Reed's counsel was prepared to present the evidence presented here at the July 1st in-person hearing. However, after delivering its prepared remarks, the court left the bench and refused to allow any party to be heard. Me. We are going to just keep grabbing shovels and digging the hole down to Pettytown, aren't we? Everybody's just like, I've got a shovel, you've got a... Somebody's going to get out like a backhoe at some point. Like the shovels aren't going to be enough. We're going to be like trenching just to Pettytown with all of this. Because Judge G had the petty, snappy footnotes in the last order that we read, where I was somewhat aghast that the footnote was, I mean, they haven't turned it over, but I'm not really that pressed about it because Karen Reed's attorneys haven't turned this over. Reed's counsel was prepared to present the evidence presented here at the July 1st in-person hearing. However, after delivering its prepared remarks, the court left the bench and refused to allow any party to be heard. That's all true. However, is the judge is just going to be like, me. Nobody cares. No, everybody's going to continue to be petty. The pettiness will endure. It goes on to say, thus, the foundation upon which the court relied to suspend Proctor's deposition was mistaken, and the court should vacate its order to avoid unnecessary delay in discovery, particularly where the second day of Proctor's deposition is already scheduled for July 14th. Oh shit, that was yesterday. Oh no. Oh no. Oh no. Oh no. Oh no. I don't have the oh no soundbite, but in my brain it's going, oh no. Yeah, that one. It's doing that. Oh, no. I don't know if he sat for it, you guys. We're going to have to go through all this. I don't know what the judge does. Thank you for no spoilers. We're going to find out together because the judge, there is a endorsement order on this that I haven't read yet. So something gets ruled on. I just don't know what happens. But I didn't know it was scheduled for yesterday. The thing is that the lawyer's argumentation isn't wrong. The court, the problem is that the court said that they do not know which lawyers leaked anything, but the court believed, based on the limited things that it apparently had seen, that this information must have come from one of the attorneys. And so the remedy for the court was to pull everybody into court and admonish all of the lawyers and yell at them, and then tell them to all have a good 4th of July. But when the court stayed the discovery for Proctor, the only party that really hampers is Karen Reed. I am open to discussion about whether the Reed party is not the most impacted party by delaying Proctor's deposition, but I do think that the Reed party is probably the party in the wrongful death lawsuit that is the most impacted by not being able to continue with Proctor's deposition. I don't think the bars care. I don't think CF McCarthy's in the waterfall is like, okay, whatever. And I don't know if the O'Keefe parties are all that pressed about it either. Because the O'Keefe party's side of this is we're suing Karen Reed for wrongful death. The investigation was fine. So there is one party that is more impacted by the court's order without any process or finding. Like if you're going to fine an attorney, there is process. If you're going to hold someone in contempt, there is lengthy process. There was no process here. The court was just like, I think, vibes, that my impoundment order was violated, as to Trooper Proctor. So therefore my remedy is no more talking to Trooper Proctor. Okay, but if you don't know what happened, and it just, the inefficiency of that frustrates me. There are times I feel like this judge is just making very quick decisions that don't seem to be anything beyond just punitive. It feels like the judge is like, I'm pissed. Y'all didn't do what I said. Sit down. It feels like a reactive timeout. Impulsive. Thank you, chat. A lot of you helped fill in the world. Yes, rotten milk, impulsive. It is. It does not feel thoughtful. And the lack of the court, because again, I think that the court could have said, and this is just, I'm not the judge. I don't want to be a judge. I've never really wanted to be a judge. I don't want to be a judge. It's a lot of paperwork. And it's like all day decision making and executive functioning. But I've worked with judges. I am friends with judges. I have appeared before many judges. My camera was just like, I know, girl, we're frustrated too. That was on my end, not yours. And there were lots of things the judge could do. The judge could have sealed the hearing because it was about an impoundment order. That would have been reasonable. Would we have been annoyed? Sure. Would it have been reasonable? Sure. Could have had a sealed hearing and candidly asked the lawyers what is going on. And the judge could have said to the lawyers candidly, if this continues, I know how heated this case is, but if this continues, these are the remedies that I will pursue. I will either default the case. I will dismiss the case. I will pursue contempt or sanctions. These are the remedies. I will disallow further discovery. I won't extend the discovery deadline. These are all of the remedies, but I need to know what happened because I don't care. And it's fair for the court to say, I don't care what anybody may think about former Trooper Michael Proctor. There is court process and that process should not be violated no matter who the party is on the other side. And then give the attorneys the opportunity to say, actually, Your Honor, the internet has already discovered this information. So anything that former trooper Michael Proctor's lawyers put into writing was already known before even the lawyers knew it, because when did the lawyers find out all this information? Because it seems from the way the court approached this that the lawyers found out the bulk of this information when that filing was made during that hearing. Not before, but there was so much speculation that happened before that. And it's not wild speculation that when someone in 2026 is in a bit of hot water, that they might seek treatment, and the propriety of that and the timing of that might seem odd. Shocking. Shocking. And if people are speculating about that and happen to be right, it doesn't mean that there's a leak. So it frustrates me the way that the judge is going about this, because it feels like the judge has made themselves an adversary to the lawyers in this, when the judge is supposed to be a neutral arbiter. And there are times that the judge wilds out on all the lawyers, but when we see the judge put down a sanction, this sanction only really impacts one party. Well, impacts one party the most. And that starts to get into frustrating to see that the judge is constantly locking horns with the lawyers. A referee is not in the game. And it feels to me that Judge G wants to get off the bench and be an advocate. And that's not the role of a judge. Their role is to literally be the referee. It's not to make the law, it's to interpret the law. It's not to advocate for one party or the other, it's to call balls and strikes. It's not to make arguments on behalf of one party or the other, though we've seen judges do that sometimes, especially when the lawyers are close. We saw Judge M do that, where it's like, the lawyers brought this up, and to the side of that, there's this, and I have to follow the law. We've seen judges do that with pro per defendants quite a lot. Hey, in the TikTok psychic case, hey, you filed your extension for time improperly on your appeal. We know what you want, so we're going to fix it. We know what you mean. And so it feels like the judge is, and I don't know this judge from other cases. I don't know if this is how this judge gets in other cases. I have been before judges who are consistently adversarial to all of the lawyers. So we'll see. But the lawyers being like, oh, you would like to play? We would like to play is just going to make all of this worse. But also, I don't know if they care. All of it exhausts me. This would not happen in an EDP court. A court by EDP's liking. It would be like, children. If I want fighting like this, I can put a bunch of 8-year-olds in the backseat of a car and go on a road trip. Like, I don't need grown-ass lawyers doing this. Go read like law Twitter if you would like to just fight with sassy footnotes. We're not doing this. It's exhausting. But Karen Reed's team is not going to back down on this point because they are the party being impacted, and I don't fault them for that. The sassy footnotes are not going to help, but also I don't think there's any way to bring the temperature down on this at the moment anyway. So they've done what I'm not surprised that they did, which is they tried to bring out the same information in a different way because the judge said, this is not what a motion to clarify is for. Fine. Here's a motion to reconsider. Let's do it that way. Let's do it that way. They go on to say, and I imagine this is mostly what they said in the last motion that we read together, but we're going through it anyway because I don't know. Oh, there's a footnote too. Sorry. I soliloquied too hard. Proctor's deposition, I was going to say disposition, wrong. Proctor's deposition is already scheduled for July 14th, footnote 2. Oh, that's a long footnote. Reed brings this motion on emergency basis because the second day of Proctor's deposition is already scheduled for July 14th, and all counsel and parties have already planned for that date. It is particularly important to protect this scheduled date because Proctor previously asserted that he had limited availability. Remember, Your Honor, on the day he was supposed to do the depo and you had an emergency hearing in the morning and then you said you were going to punt till 4:30 and then we burned an entire day and then you're like, do your deposition tomorrow. And everybody's like, we're not available tomorrow. That. So they say it would be unduly and unnecessary. I think unduly is also unnecessary. No, that was unnecessarily. I take that back. It would be unduly and unnecessarily costly and burdensome to force Reed to miss a previously scheduled deposition day because of the order. I disagree with the languaging. I don't disagree with the sentiment. The vibes are accurate. Your Honor, we have nothing that indicates your order was violated. Please remove what you see as a remedy to a violated order because the order wasn't violated. That's reasonable to me. Let's see. It would be unduly and unnecessarily costly and burdensome to force Reed to miss a previously scheduled deposition day because of the order, which was based on an incorrect premise. I wonder if they would get further with this if they said, we understand that the information presented to the court was this. That information is incorrect. That is not on the court. It is unfortunate the court was presented this information in this way. But now that we've presented corrected information, can the court please conform the order to the corrected information? However, I don't think these lawyers are about to like pretty v please with the judge. And that never really hurt my feelings when I thought judges were being unnecessarily driven by their own hubris. I was just like, whatever. Oh, wise court. Oh, wise, Your Honor. I don't give a shit. I need to get done what I need to get done. Do you need me to just tell you that you're pretty? Fine. Your Honor, you are so smart. So wise, so learned. Can we please do this? Thank you. Thank you. Thank you, Your Honor. Then again, some of us learn that early in life. It's just like, whatever. I can be water. I'll be malleable in this. It's fine. End result is what we're looking for. It's fine. I don't give a shit. It's fine. I don't need to fight with you. Just, can we get this done so I can get into another court, please? Because I definitely dealt with some difficult judges. Stories for other days. I don't know. Maybe sometimes lawyers need to be malleable like mercury. It's like, we can be fluid, but also deadly. Reed's counsel conferred with Proctor's counsel concerning this motion prior to filing it. Fine. Oh, I missed a sentence. Were Reed to serve this motion via Rule 9A, the opposition would not be due until after the currently scheduled date. Reed's counsel confer with Proctor's counsel concerning the motion prior to filing. So Reed's counsel is saying, we told Proctor's motion we were filing. We told Proctor's lawyers we were filing this because now they have to let Proctor's lawyers. I think in this context, that's correct. But remember, the court clapped back at Reed's lawyers and we're like, did former Trooper Michael Proctor's lawyers know that you were suing MSP the day before his deposition? And they're like, huh? What? Why? Why would we do that? We're not suing him. He's already been sued. So they reminded the court, yes, we've already told him. We're trying to speed this up. The court goes on to then, no, not the court. Reed's attorneys then go on to say what it looks like they said previously, that the post on the platform formerly known as Twitter was created at 10:52 a.m. Eastern time. The court stated at hearing that it was staying further discovery of Proctor because Proctor's counsel sent certain impounded pleadings and exhibits to the court and counsel at 2:22 p.m. on June 8th, and that the X post in question was created exactly 30 minutes after the email to counsel of record. That is exactly what the court said. And we were all like, what tweet are you talking about? They say the court said that the tweet contained information, quote, similar to the information contained in Proctor's filing. They go on Reed to say that that is incorrect. The court was like, it was similar enough that it could only have come from this source, which also is just, it's a reach for me. Because, I mean, we're lawyers. Most of what lawyers begin with is, I mean, it depends. So where's the it depends? It could only come from here. How are we narrowing down something? How are we narrowing down the internet, Your Honor? Good Lord. They say that as the court can see below, the ex post in question, which was provided to the court by Proctor's counsel, I was stunned at that reveal. Also, I wish there was a little bit more, I don't know, mindfulness by the court when this is coming from one party's counsel to ask some follow-up questions. Because if you just look at lawyers following their own best interests, that's basically the job of the lawyers, is to follow the best interests of their client, right? There are ethical rules on that. There are more stringent rules in criminal. Civil is a little bit of a different matter. If Proctor's counsel is submitting this, who stands to benefit? Right. So maybe a few questions. But now it is not lost on me that we are back talking about Karen Reed, and we are fighting over time being a construct. So Proctor's counsel, in a letter that prompted, there's new information. Wait, there's new information. Come on back. There's new information. There's new information. Proctor's counsel, in a letter that prompted the court's June 30th order, that's the one that ordered that hearing, was created at 10:52 a.m. Eastern time. So Proctor's counsel sent a letter to the court. Hopefully everyone else was CC'd on it. The image provided by Proctor's counsel had a 2:52 p.m. timestamp. However, that is because it was apparently accessed by a user without an X account, or not logged in, which actually, on behalf of lawyers, smart to not be logged in if you're using any social media platform and gathering information, because there's issues with that. But it was apparently accessed by a user with an X account or without an X account, which defaults to UTC. I didn't know that, but defaults to UTC 4 hours ahead of Eastern time. And then they have a link to documentation from Twitter. When accessed by a user without an account set to Eastern time, the post appears as follows. And then they have the post. We went over this in the motion to reconsider. It was Turtle Boy's post. And they show that the post appears at 10:52 a.m. June 8th, before the Proctor filing. The message was actually posted more than 3 hours before Proctor's filing and not, quote, exactly 30 minutes after it. Therefore, it does not prove or suggest that anyone has violated the court's impoundment order. Nobody had the information yet, Your Honor. Can't leak what you don't know. Unless we're talking about information that magically ends up in the hands of like TMZ, and then you can only look at who had the information before anybody else did and ask those questions. They go on to say, therefore, it does not prove or suggest that anyone has violated the court's impoundment order. And then they underline and italicize the information in the X post the court referred to was public 2 days before Proctor's counsel filed or served the pleadings and exhibits the court relied on to justify its order. On June 6th, the X user the court referred to on July 1st held a live stream on YouTube during which he stated that he had received the same information from a third party. And we had seen that information rumbling around on the internet. And when people asked me about it in chat and said, do you know if this is true? I said, these are rumors. We're waiting for court filings. The rumors, the speculation, the nastiness. Yeah, we're waiting. Oh my God. I made a Meredith Marks reference to Travis. As we were talking, there were a couple other members of CCG, the Cavaliers color guard, around. And like 3 of them turned around and went, yes. And I was like, oh, God, I love you guys so much. Someone made a Reading Rainbow reference. It was a delight. I can't tell you how delightful this group of humans is. It was an absolute delight. I was delighted. One of the other, Emily, you're sidetracking real quick. I was standing with a number of other parents, and a large group of the kids were, the event we were at was a Rosemont parade and picnic. And so the Cavaliers were just hanging out at the picnic with the community, with kids in the community, adults in the community, because they are from Rosemont. It started in 1948 in Rosemont. They were one of the original drum corps that was part of Drum Corps International when it became DCI. Either way. So as we are sitting there, and all of you who have had to interact with people that you don't know well at any type of thing, you never know if you have found your people, if people won't get you. It is always just like, hi, how are you? And at least with DCI, it's like, what does your kid play and whatever. So a group of kids were leaving, and the other mom that was standing there was like, have fun storming the castle. And I was like, oh, my people. And so one of the kids chuckled. A number of the other kids didn't. And I'm like, this is a 10 out of 10. And I love that you said that. I'm like, I need you to tell me how many kids get it. She's like, it's a handful of kids that actually get it. I'm like, and those kids, she's like, those kids are parents I want to talk to. I'm like, those kids are parents I want to talk to too. And so she's like, have fun storming the castle. I was like, I loved it. I loved it. I loved it. Norton said, wait, are you talking about Rosemont, Illinois? Yes, I am. Yes, I am. Yes, I am talking about Rosemont, Illinois. Yes. Yes, I am. Which is fantastic. Allison in the chat said, we'd sometimes get the Cavaliers in our 4th of July parade, Arlington Heights, one of the biggest of the Northwest suburbs. Huge highlight when I was growing up. And the Cavaliers did 3 4th of July parades around the Chicago suburbs this year. But that picnic was really cool to see. The Cavaliers just, hanging out and interacting with the community, and how much the community is connected to them, because there are places that I recognize from Drum Corps, like Rockford, Illinois, because it's the home of Phantom Regiment. And also, every time they announce the corps, they announce where they're from. So where they're from is a thing. And you'll see the Cavaliers with roses in different aspects of their merch and stuff. That's all for Rosemont. And it is the exact same rose that the village of Rosemont uses. So yes. So there are those little connects. Sorry, I just sidetracked, but the have fun storming the castle was one of those 10 out of 10 moments where I was like, oh, okay, great. And that doesn't surprise me, because band parents are invariably easy to talk to. And it's always an easy conversation to start. Hey, what section is your kid in? Because I don't ask what your kid plays anymore, because I'm a guard mom. And so what does my kid play? Guitar, but not here. He plays rifles, which always sounds weird. So weapons, he spins weapons. He throws sabers and stuff. So I always ask, what section is your kid in? Where else have they marched? Do you have a favorite show? Stuff like that. It just opens up the door. So that was fun. It was really fun. I have a huge thank you to Cindy. Cindy, thank you for the 50 gifted memberships. Welcome all the new Lawnerd members. Thank you. I appreciate it. Thank you so much. All right. Now that we've sidetracked just a little bit, let's get back to what in the world is happening here. Live stream, YouTube, information about where Proctor was. I do not spend a lot of time on this part of the internet. Right now, my internet is full of DCI stuff. My algorithm has been tuned in. I open the algorithm and it's like, hello, music, and it makes my heart happy. But when I say this to say, when this information trickles down to me, I know that it's not out there in a limited way. It's out there. By the time I've heard about it, it's out there. We're hearing about a series when book 3 is already out. We're not clocking this before it's even released. We're not that early to the party. You know, we're not the first ant to the picnic. So, June 6th, the ex-user, Turtle Boy, had a live stream, talked about this information, said that he got it from a third party. That was 2 days before the filing. The YouTube clip is attached on a USB drive. The court has done that before, or this party has submitted that to the court before in the last filing as well. And then the following posts, there's a footnote on that, also predate the June 8th impounded filing, also show that the information in question was public prior to that filing. I even asked those questions when we saw that Friday filing. I'm like, oh, what's the excuse going to be? Proctor is immediately unavailable. My brain went the same place. Where's Proctor going to be? Because it's an easy guess. If it's like, we didn't know what was happening, all of a sudden he's unavailable. Okay. It doesn't really take a lot of forethought to be like, where's he going to say he is? But this shocks no one. Let's see what the footnote is. We've read these posts previously. This is a post asking, which do you believe will most likely happen on Monday? That was the hearing on Monday. Judge grants the motion, denied, and deposition, denied, and no deposition. Footnote 3. Reed is mindful of the court's prior statement to counsel that social media posts, quote, are not evidence. However, they are relevant here because the court expressly relied on social media posts as justification for its order. Oh, the hypocrisy. Social media posts are not evidence. Okay, then why is there a discovery sanction? And I say sanction because this is something that impacts discovery. So it is a sanction. Why is there a discovery sanction based on a social media post then? Okay. And these were posted. This is a repackaged, and I'm not saying that in a negative way. This is a repackaged motion for reconsideration because the court said or a motion for clarification because the court said there's nothing to clarify. So now they're asking the court to reconsider. They go on to say the court's remedy for what it incorrectly determined was a violation of its impoundment order has primarily impacted Reed. I'll keep reading, Emily. I mean, again, this is obvious, right? Because they are the party who subpoenaed Proctor before taking his deposition. They are the party who subpoenaed Proctor, began taking his deposition, scheduled a second day of testimony, and spent significant resources compelling and taking his testimony. Additionally, despite the fact that there is no evidence of any violation of the court's impoundment order, Reed has, as the court instructed, made a proposal to all parties concerning an order she would agree to propose to the court concerning deponent's medical information. Oh, interesting. So they did reach out to the parties and say what? We will follow the rules. ADHD Architect said Dubuque, Iowa has a DCI core. Is Dubuque the Colts? Are the Colts Dubuque, Iowa? I try to get these right. I will know. Troopers are the only ones in Wyoming, so that's always easy for me. But I think the Colts are Dubuque. So, Santa Clara Vanguard's pretty easy for me. They put it in the name. But what's the order? Hey, we'll follow what we've already been told to follow by the rules. We'll just follow the rules that exist. And I don't think Karen Reed's attorneys or any of these attorneys are trying to put Proctor's personal medical information out there. However, his attorneys were pretty forthcoming in the hearing that was public that it was medical information that they were submitting. It's not hard to kind of connect the dots on that. I don't know. Was it his blood pressure, counsel? Was he having high blood pressure? Was Alan Jackson going to make it worse? Whatever. The thing that was of interest is that the filing was made Friday before the deposition was scheduled for Monday, right after the filing dropped with all of those horrific text messages. That is why there was so much attention on it. So Reed's attorneys say that Reed has proposed an order to all parties. No other party has responded to Reed's proposal. Shocking. They're all not talking to each other. I'm not surprised that no one, we've seen the way the emails have gone. I'm not surprised that everybody's just like, whatever, we'll sort it out in court. And now the court's going to end up with exactly what they didn't want, which is everything needs to now go through the court. The court has inserted themselves as like mediator, judge, mommy. And now everybody's just like, mom, can we do our deposition? Mom, can we have a snack? Mom, I'm thirsty. Mom. The court has turned this into just a game of like, mother, may I? It's wild. Mom, mommy, mama, mother. May we take our deposition? May we continue discovery? Mom, they're touching me. This one. Felicia in the chat said, Mom, the meatloaf. I agree. In the chat, Tian said, I think everyone needs a cookie and a nap. I do. I think we need to feed the lawyers. I think we need to feed the lawyers. They're all acting like they're in the second week of a keto diet. I think we do. We need to feed the lawyers. Everyone's way too cranky. They go on to say that this comes on the heels of Reed earlier proposing to all counsel that witness testimony in transcript, audio, or video form only be used for the ongoing litigation and not otherwise disseminated. I wonder if the other parties have a problem with that. Because I can see a circumstance where the other parties are like, but there's 3 other litigations and we would sure like to use it there too. So I wonder which attorneys are fighting over, yeah, but we want our depositions for the other cases. Katie says, should we send them to a rage room? Yes, as long as it has like copying machines and fax machines. So Reed said that they are fine with all of the transcript, audio, and video of the witness's testimony being used for this lawsuit and not the other lawsuits. I imagine the lawyers are just like, well, like if I'm one of the third party witnesses in this case, would I want to have my deposition before the other cases? Yeah, I can totally see a circumstance where you would want to review that before your other deposition. Sure. So they asked the court to reconsider and vacate the order and allow Reed to proceed with Proctor's deposition July 14th. Mom, mommy, mother, mama, mother. May we please proceed with our deposition? Well, we need to take a look next at Proctor's opposition. I have no idea what the opposition is. I wonder, and I have not read this, I wonder if the opposition is, hey, we want to continue with a protective order in place, or if it's, we're not continuing with our deposition at all. I'm curious which one it is. Let's see. All of you in the chat being like, PC load letter. What is a PC load letter? I love that all of you got the Office Space reference. Says the girl who spent a fair portion of her career being of indisposable value because I could fix the copying machines and the printer copying machine. Apparently my software would like to update. Wants you all to know that it needs to update. Yes. I was actually pretty good at fixing a copying machine or a printer and email. Lawyers and technology, I don't understand why lawyers and technology don't go well together, but it is a universal truth that lawyers and technology don't go well together. I love technology. I was like, let's go. Let's go. If you are interested in being legally adjacent and understand technology well, the law is going to need you. You do not need to go to law school. There is going to be, I think, a growing career path in tech consulting / technologically advanced paralegals. I think there's going to be kind of a new industry that helps attorneys and law firms from absolutely embarrassing themselves when it comes to technology. Okay. Non-party Michael Proctor's opposition to Karen Reed's emergency motion for reconsideration of order delaying deposition of Michael Proctor. Non-party Michael Proctor submits this opposition to Karen Reed's emergency motion. I'm not saying the whole title again. But it ends with, Mr. Proctor will be brief. Wonderful. As an initial matter, Ms. Reed's motion should be denied because it fails to even address the fact that the information regarding Mr. Proctor's _ medical condition and his deposition was disseminated by Aidan Kearney, aka Turtle Boy, within 30 minutes of the conclusion of Mr. Proctor's June 25th, 2026 deposition. I'm sorry. First, didn't the court issue the order regarding a tweet from before the deposition? Why are we moving the goalpost? The court ordered a stay on Proctor discovery based on allegedly a tweet from June 8th after a filing was made. Why are we jumping to June 25th? Reed's attorneys, sometimes with, additional hyperbole, but Reed's attorneys and snark are addressing what the court said. Why are we shifting this to June 25th? Can we all stay focused? Okay. So now Reed's attorneys say, hey, Your Honor, you said, because that's a dead ass what the court said on July 1st, is that Proctor's lawyers filed their impounded information about Proctor's medical whatever. And then within exactly 30 minutes later, there was a tweet about it. And now Proctor's lawyers are coming in saying, but Your Honor, they failed to address the fact that Proctor's medical condition was released within 30 minutes of his deposition on June 25th. What the fuck? But the court didn't rely on this in their order. Why would they argue something the court didn't rely on? And why are you bringing up now? Oh, if the court cites this, I'm going to lose my mind. I'm going to lose my mind. I'm going to lose my mind. Y'all going to make me lose my mind up in here. Up in here. Oh. God, this pisses me off. It's so disingenuous. Okay. Rant. We're going to keep going. This is so frustrating to me. The judge ordered A. They argued A. And the other side's coming in and going, but Your Honor, what about B? Fuck you. What do you mean, what about B? We're talking about A. I hate it so much. It just... Why are Proctor's lawyers just channeling Sarah Boone? What are we doing? And this is an opposition. Your Honor, it should be denied because of thing no one's ever brought up before. Brand new information. All right, what's the brand new information? As an initial matter, they say Ms. Reed's motion should be denied because it fails to even address the fact that information regarding Mr. Proctor's medical condition and his deposition was disseminated to Aiden Carney, aka Turtle Boy. Would that be an AKA or a PKA? Either way, within 30 minutes of the conclusion of Mr. Proctor's June 25th deposition, specifically on June 25th, 2026 at 5:30 p.m. Oh, do we know how to use Eastern time now or not? Do we only do we only use like UTC when it's beneficial? Like, do we log in now or not? Specifically on June 25th, 2026 at 5:30 p.m., Mr. Carney posted on his X account, and then they put the handle in at Dr. Turtleboy as follows. Quote, breaking news. Michael Proctor claimed, in bold, to have a panic attack today and left his deposition, emphasis added. Wait, did the lawyers add the emphasis? Why add emphasis? Okay. Why are you adding the emphasis? I have personally verified that, and they say spelling an original, that was seen outside. I don't know if that said Proctor or something else, that it was seen outside being consoled by his lawyers who were asking him if he could continue. No word yet if he did. First of all, you citing it verifies that it's true because you're verifying that that's true then, that he claimed to have a panic attack. And you're saying that he was seen outside being consoled. Would anyone be surprised? I don't think people should do this, but it wouldn't surprise me. Would anyone be surprised if there was someone just parked outside the law firm the building where this deposition was happening, waiting to see if they saw anybody coming and going? A la TMZ or whatever. Would this surprise anyone? Wouldn't surprise me. Yuri Buchanan goes to a Dave Matthews concert, and I heard about it from quite a few people also. I would not love to run into Yuri Buchanan at a Dave concert. It would kind of wreck the vibe. But with everything going on, eyes are on these parties. And I have the sense that those in the greater Boston area don't have a lot of love for Proctor, or at least the ones that don't have a lot of love for Proctor aren't going to hesitate to DM Turtle Boy and be like, yo, guess what I saw? That shocks me not. It surprises me not. Everyone knew what day he was doing his deposition. This is outside. Okay. I saw a great question in the chat. CMK said, what is a PKA, professionally known as? I always look at otherwise known as or also known as like an alias, where professionally known as is more of a stage name. And I don't know if it matters, but professionally known as would be more like a stage name, like Turtle Boy, or pick an artist with a stage name, Lady Gaga. I mean, right? PKA. We saw PKA used appropriately in like the Cardi B case because it's really not an alias. It is a professionally known as. Anyway. So I'm not surprised that he was seen outside of where this deposition was taking place. The building where the law firms are is probably fairly well known. They go on to say, this is Proctor's attorneys, that the information was accessed by a user with an X account, footnote 1. A screenshot of the X post follows. Debbie Jo said, so PKA is not short for Pikachu, not in this context. So they have a screenshot of the tweet from 5:30 p.m. June 25th, 2026. Well, then why did you quote it above? The exact same one. And then they have a couple of responses. Breaking news. Michael Proctor claimed to have a panic attack today and left his deposition. I've personally verified that he was seen. That was seen outside being consoled by his lawyers who were asking him if he could continue. No word yet if he did. Somebody responded to him and said, post the pic. Turtle Boy responded, can't, unfortunately. In point of fact, Mr. Proctor did continue his deposition, and the deposition was suspended shortly after 5 p.m., assuming arguendo that the X account did not default to 1:30 p.m. Eastern Standard Time, and they put default in quotations. And given that this X post was accessed by a user with an X account, Mr. Kearney posted on X within 30 minutes of the conclusion of Mr. Proctor's deposition that Mr. Proctor, quote, claimed to have a panic attack and left his deposition. The footnote said Mr. Proctor acknowledges that the X post referenced in Mr. Kearney's June 8th, 2026 post was accessed by a user with an X account. Is that a typo? Mr. Proctor acknowledges that the X post referenced in Mr. Kearney's June 8th, 2026 post was accessed by a user with an X account. That is the worst sentence. Are they trying to acknowledge that they had a time zone issue? And did Kearney reference a different X post within his X post? And this is the worst sentence. Because I don't know if they're trying to say that Turtle Boy was reposting an X post on the 8th, or if they are trying to acquiesce that they did in fact have the UTC time on the June 8th post that Turtle Boy made. It seems to me like they're trying to oh yeah, we also were using UTC. But it's a really, really terrible sentence. Okay. It's just a word salad of a sentence. The kind of word salad that gives you just explosive diarrhea. Emily, are we making jokes? Look, man, I'll let you know, the entire time I was traveling, I was like, there is not a vegetable in sight. I do not have time. I do not have time. Nope. You know what hasn't been linked to all of the tummy troubles going on? Animal crackers. Not a single problem. I'm like, I am good. Coffee is safe. Do not bring a leaf of lettuce near me. No green onions. Nope. It's fine. It's fine. No vegetables. None at all. So that. All right. Let's see. Chicken nuggets seem to be safe. I also, Chad is saying no cilantro. Fair. And also, I'm one of the special and lucky folks that cilantro does in fact taste like soap to me. So no cilantro ever. But no guacamole. Love my paw nerd said Oreos. Yep, completely safe. Completely safe. Sour gummy bears, all good. This is life advice. So I'm not sure if they're trying to acknowledge that the previous tweet that they shared with the court, I'm going on vibes because this sentence is shit. I'm going on vibes. It seems that they're trying to acknowledge that the timestamp on the X post that they talked about previously might have in fact been wrong. And I'm making that conclusion because the way that the attorneys are arguing this is shifting the goalpost, and they are shifting it to, but after Proctor's deposition, this information was leaked. So they've said, okay, we concede June 8th. We're moving on to June 25th. Here's the next problem. So that's why I'm reading it that way. Shocking. Continuing on. It seems to me that by arguing this, they are arguing that Turtle Boy was correct. Accordingly, the fact that Turtle Boy posted that, quote, Mr. Proctor left the deposition but had no word that he did continue the, oh God, okay. Let's start this sentence over again. Accordingly, the fact that Turtleboy posted that, quote, Mr. Proctor left the deposition, end quote, but had, quote, no word that he did, end quote, continue the deposition, strongly implies that Turtleboy had this information while the deposition was ongoing. Maybe from somebody that saw him outside. There's a lot of ways this information can come to a person, and it also depends on where the deposition is being held. Maybe we'll find out more. It's law clerk season, everybody. However, if you're a law clerk and you don't want to get an offer, leaking information on the internet's a good way to do that. So they are making the conclusion that Turtleboy had information while the deposition was ongoing. They say, more importantly, the fact that Turtleboy posted that Mr. Proctor, quote, claimed to have a panic attack today and left his deposition implies that Turtleboy was aware of what was said during the confines of the deposition, footnote 2. So it's true then. So it's true. You're agreeing that it's true? Because if it wasn't true, why would we be fighting this? Footnote 2. As noted above, in response to another ex-user's request that Mr. Kearney, quote, post the pic, Mr. Kearney responded, can't, unfortunately. Why is that a footnote to that sentence? That doesn't even make sense. They go on to say, to be clear, at no point has Mr. Proctor, quote, pointed the finger or otherwise accused any counsel or party of disseminating impounded information. Huh? What is, excuse me, I'm going to need some work in your transition sentence. What? Who were you quoting? Didn't the judge yell at everybody for using quotes and not telling us who the quote's from? Who said that Proctor pointed the finger or accused anybody? Where is this coming from? What are you talking about? They go on to say that Mr. Proctor takes no position on that point. Did we miss a page? Where does it say that Proctor's attorneys pointed the finger at anyone? I'm just confused. All right, I'm just reading what they say. Chat's like, make it make sense. I don't know what they're talking about because it Reed's attorneys didn't say that. We just read their motion. Reed's attorneys said that the court's order harmed them because they're the ones who are trying to depose Proctor. They go on to say, after these lacking transition and clearly confusing, like they've started their conversation in the middle and haven't clued the rest of us in on their conversation. But they say, given, however, the existence of the court's orders of impoundment and the sensitive nature of the impounded information. I mean, you just told us what it was, though. Hello, Streisand effect. You've just told us that what Turtleboy apparently said, that Proctor claimed to have had a panic attack, is true. Because you just said that him tweeting that indicates that he knew what was happening in the deposition. Ergo, it's true. Because if he was just making shit up on the internet, would you be arguing that somebody was feeding him information? They go on to say, given, however, the existence of the court's orders of impoundment and the sensitive nature of the impounded information, Mr. Proctor felt it appropriate to bring to the court's attention information which created a reasonable inference of a violation of the court's orders. Those are the exact words the court used too. As the court noted during the July 1st, 2026 hearing, all parties and counsel certified to their lack of knowledge as to any facts regarding the potential dissemination of the impounded information. Right. Mr. Proctor's June 25th, 2026 deposition went forward for approximately 4 hours and 30 minutes with several agreed upon breaks. Mr. Proctor is a fact witness in this litigation and not a party. Despite having the opportunity to depose Mr. Proctor for hours, at no point did Ms. Reed's attorney ask a single question regarding Mr. Proctor's investigation into John O'Keefe's death. Really? Wouldn't they just start with that? They go on to say, nor a single question about Mr. Proctor's investigation into Ms. Reed's involvement in that death. Huh. I'm real curious to read the reply on this. They get to do the depositions however they want to do the depositions, but it would seem that that Proctor's trying to get out of this deposition up, down, and sideways. You think he would just start there. Okay. Interesting. Also, while I am interested in the information being revealed here, does the information being revealed here have absolutely anything to do with responding to the court about lifting the order to allow Proctor to be deposed because the June 8th, quote, leak is not a leak? No. No, this has absolutely nothing to do with anything other than being like, but Your Honor, they're not even asking about this. It seems to me that counsel's trying to imply that the time is not being used well in the deposition and the court should not allow the deposition to continue because they didn't use their time wisely. It seems that that's the direction that they're going in. And Your Honor, they had 4.5 hours. What were they doing? Let's find out. Because they start the next sentence with, instead, Ms. Reed's counsel spent much of the deposition questioning Mr. Proctor about various text messages that Reed's attorneys published in a recent lawsuit currently pending against the Canton Police Department and MSP. That is not going to make the court happy at all. Because I don't think the text messages are the most relevant part to the wrongful death lawsuit. The lawyers get to strategize their deposition however they want to. But it doesn't surprise me that Proctor's attorneys are like, but Mom, they're not even asking about this case. They're trying to pose this as if the discovery is being used for another case. That's the way they're trying to frame this. All right. They go on to say that none of these questions were relevant nor material to Mr. Proctor's investigation. I think they're relevant to the investigation. I think starting with the investigation would have made more sense. But again, it's not my strategy. And this is Proctor's attorneys playing to the court. Because the court has been very sensitive whenever the word strategy is used, even though being a lawyer is in fact strategic. Every time the word strategic is used, the court gets ruffled. So they go on to say that none of these questions were relevant, nor were they relevant to the subject matter of the wrongful death action. However, part of the wrongful death action is Karen Reed speaking about this investigation. Those text messages, I think, can go at times to the investigation. Starting there is not helpful, especially if they aren't the text relating directly to Karen Reed. Let's see. They cite Massachusetts Rule of Civil Procedure 26. Parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action. Such questioning can only be viewed as harassing in nature. Yeah, it seemed like that's the direction they were going because they've said that before. I'm not surprised that that's what they're arguing. They say, accordingly, should the court allow Proctor's deposition to continue, Proctor requests that the court limit it to 3.5 hours of deposition testimony. Interesting. Finally, Mr. Proctor points out that on June 18th, 2026, counsel for Mr. Proctor requested from Ms. Reed's counsel, quote, assurances that neither you nor anyone on Reed's team will disseminate to any outside source, including but not limited to media or social media platforms, any portion of the deposition, whether in video, audio, or transcript form. Despite being the party that subpoenaed Mr. Proctor and the only party that questioned him on June 25th, interesting, Ms. Reed's counsel has continued to state that they will not provide such assurances. Okay, but Reed's team just said that in their motion that they would agree. Well, it's different. Reed's team said that they would agree that none of the depositions can be used outside this litigation. But including but not limited to media or social media, I could see an issue depending on the wording of this, of Reed's team being like, we need Proctor's deposition to go to our experts or whatever. It depends on how narrow. I could see them fighting over the language of being like, media and social media, fine, but that this says including but not limited to. We can't agree that no one on our team is going to have Proctor's deposition. They go on to say, regardless of whether the court allows Mr. Proctor's deposition to continue, Mr. Proctor respectfully requests that the court issue an order to Ms. Reed's counsel prohibiting them or anyone else on Reed's team from disseminating to any outside source, including but not limited to media or social media platforms, any portions of Mr. Proctor's deposition, whether video, audio, or transcript form. Outside source, including media or social media platforms, is fine. It's the but not limited to language that's a problem, because if you're putting yourself in the position of Reed's attorneys, you could see that if they gave an expert this information, that you could see Proctor's attorneys coming back and saying, but that's included. So I can see where all of the attorneys don't trust the intent of what is said and are worried that they're going to end up fighting in the weeds, because that keeps happening. And Proctor's attorneys in this opposition said, oh, we're not talking about June 8th. We're talking about June 25th. Silly. When the court was the one that started talking about June 8th, the gaslighting is really just pissing me off. This is really just pissing me off. Okay. So where are we at? We have a reply and then we have an order. Reed's attorneys said, hey, Your Honor, can you please remove the stay on continuing to take Proctor's deposition? Proctor's deposition is set to continue on July 14th. And as you can tell, the tweet in question happened before the impounded information was emailed to the court and counsel. Proctor's attorneys came in their opposition and said, Your Honor, we shouldn't continue with Proctor's deposition. And even if you do, you should limit it to 3.5 hours, because Reed's attorneys, someone was giving Turtle Boy information during the deposition of Proctor, as proven by the fact that Turtle Boy tweeted out a half hour after Proctor's deposition ended, saying that he claimed to have a panic attack during deposition. Proctor's attorneys say that that proves that Turtle Boy had information about what was being said in the deposition, thereby confirming that it is in fact true. Proctor's attorney shifted the ball from the June 8th tweet, and they seem to concede in the worst worded footnote I have ever seen. They seem to concede that the UTC time was in fact a wrong time, because then they made much of saying, and these Turtle Boy tweets that we're putting in these filings were accessed by someone with an account in Eastern time. So we have the proper time zone on these. And Turtle Boy was tweeting out about what was happening at Proctor's deposition. And so someone is telling him what's going on in the deposition room. And then they went on to say, and in the 4.5 hours of deposition, Karen Reed's attorneys never even asked about the investigation into John O'Keefe's death, and only asked, they say, about text messages and the text messages that were in their pleading against MSP. So let's see what Reed's attorneys have to say when they respond. Lyndon pointed out something very critical in the chat. Lyndon said, exactly 5 billable increments. Yes, they're doing everything in billables. So let's take a look at Reed's reply to this wild opposition of, this is just a game of move the ball, move the goalpost. How wild. All right, let's see what Reed's team says. This was filed July 9th. It wasn't docketed until the 10th, so I pulled all these from the 10th, but this was filed July 9th at 11:15 a.m. This is Karen Reed's reply in support of emergency motion for reconsideration of order delaying deposition of Michael Proctor. Oh boy. In her motion, Reed addressed the information the court referred to as the basis for the order Reed asked the court to reconsider. Right. The court entered that order because it concluded that impounded information had been shared with a non-party. As explained in Reed's motion, there is no evidence that that occurred. Thus, the order based on that conclusion should be vacated. As the court and Michael Proctor's counsel are aware, Reed has already specifically addressed the different ex post included in Proctor's opposition. Really? Oh my God. It really is like kids fighting at this point. So there are other filings where this was addressed. So every time Turtle Boy tweets, everybody has to like respond to the court? Is that what's happening? How many billable hours are going to have the code Turtle Boy Twitter on them? Take a guess in the chat. How many billable hours? So Reed already addressed this? Reed did so in Reed's letter to the court in response to Proctor first raising this issue in a letter on June 26th. Doctor Who in the chat with the swiftness saying about 6-7. A lot of you in the chat just immediately went to 6-7 billable hours. I think 6-7 is the appropriate response. Some of you have said the limit does not exist. Touche, Shaylin. Yes, the limit does not exist. Some of you said 227 billable hours. Exactly. Or 2 billable hours and 27 minutes, depending on how you read it. So this is new information. Reed addressed the Turtle Boy tweet from June 25th in a response to the court because Proctor's attorneys went to the court and raised the issue on June 26th. Those are not on the docket because those are letters to the court. Those are not on the docket. I'm going to pull the docket up anyway. Emily, that's a terrible plan. Yeah, I'm going to do it anyway. Emily, that's a bad idea. Every time we pull up this docket, there's a flood of new shit on it. I know. But there have been days where I've checked the docket and there's nothing. And then 4 days later, there's stuff that appears backdated because it's not consistently, it's challenging. But I'm going to pull that up because I saw nothing. I worked 10 hours and all I want, yeah, that is Wingstop. So I'm going to pull this up real quick and make sure there's nothing from those dates because I didn't see anything and it doesn't mean they don't hit the docket later. All right. Just wanted to have that up so I can take a look at it because apparently there were letters to the court on June 26th. Let's find out what they say it says. Reed's letter to the court in response to Proctor first raising this issue in a letter on June 26th. As Reed explained in that letter, the post Proctor cites from Turtle Boy itself states, quote, Proctor was seen outside being consoled by his lawyers who were asking if he could continue. No word yet if he did. They left some of that information out, though. They left out the other part because Proctor's side has the whole quote. Breaking news, Michael Proctor claimed to have a panic attack today and left his deposition. I have personally verified that he was seen outside. Reed's team left out the claimed to have a panic attack today and left his deposition. That was the part that it seemed the lawyers were the most fluffed about, because of course they're fussed. That information seems to come from inside the building, not outside the building. And Reed's team just kind of sidestepped it and put in half a quote of Proctor was seen outside being consoled by his lawyers. They go on to say someone outside of the deposition saw him, and Mr. Carney was unable to report whether or not the deposition concluded. They're not addressing the issue, though. They go on to say this does not suggest in any way that someone in the deposition shared any information with anyone. In fact, it suggests the opposite. You skipped half of it, though, counsel. Where's the rest of it? Proctor spent multiple hours outside the office where the deposition took place, and presumably sometime outside the office building. Carney's post explains that the information he shared made its way to him because Proctor and his counsel were observed in public. Other social media activity provides even more detail on how this information became public. And then there are screenshots. I mean, at least they're using dark mode. There are screenshots of other tweets. One that's a reply to a post that we don't have, but there's a reply that says he showed up and had a panic attack in the hall outside. And that's from 11:29 a.m., June 25th. But I don't know what that's replying to because we don't have that. Somebody asked prediction or fact. And then the user says, I saw it with my own eyes on a security camera, but cannot share it. Well, I imagine building security is going to be interviewing everyone, right? But also, does this not remind us of the Cardi B case, where Cardi B was really upset that someone saw her, a security individual who could guard a building, saw her in the hallway and was worried that information would get out there because she was walking to an OBGYN's office and she didn't want anyone to have that information. Just Call Me Hen said, why are people getting access to security cameras? They might be working security. It might be someone who is working in the security office and saw it as they were working in the security office. One of the ways, aside from this, that TMZ gets information is because courthouses, especially in Los Angeles, have a ton of people working there. Courthouses in LA have a ton of people working there, and not all of them are employed by the court system. Everyone in food service are employed by outside vendors. The clerk's office is massive. You have janitorial staff on every single floor that literally hear everything. There are massive buildings with tons of people that work there. So am I surprised that somebody's like, oh, look, that's Michael Proctor in the hallway? I'm sure the building is not thrilled by this. But, I mean, we even saw this with, remember when Britney Spears was taken to UCLA on a hold? They had people within the medical system leaking her medical records. They did a huge investigation. People were fired, but the information still got out there. Same with when Michael Jackson was taken to UCLA. Huge investigation. People were fired, but the information still got out there from people who worked in the building. It happens. People are nosy, especially when there's high profile things, and especially when people do not like the person. Am I surprised that people don't like Michael Proctor? No. Does this probably violate the rules of their job if this person is a security person and if this is true? Yeah, it probably does. Briannon in the chat said Kobe Bryant, sadly, 100%. 100%. And those were sheriffs and fire. And LA County lost a massive amount of money in that lawsuit. Yeah, if this is true. They go on to say all of the available evidence suggests that the information in question came from someone unrelated to the case. It's coming from outside the house. The call's not coming from inside the house. I think, and I'll keep reading, and maybe they do. I think that Reed's attorneys should have addressed the panic attack and not have left it out, because that seems like they are ignoring the part that Proctor's lawyers are arguing came from inside the deposition, and maybe they'll get to it down below. But it raises a red flag for me when they're only quoting half the tweet up above, because it seems that this information being shared says that Proctor's having a panic attack in the hall outside. M40A5 in the chat said, I was doing lighting checks at a courthouse and heard from a clerk, quote, he confessed to everything and got off. People hear things at courthouses. Yes. Right. They go on to argue all of the available evidence suggests that the information in question came from someone unrelated to the case. The remainder of Proctor's opposition is essentially a motion for protective order, which Proctor has not filed and Reed has not had the opportunity to oppose. If Proctor serves or files such a motion, Reed will oppose it. The opposition will point out that 1, Proctor's description of Reed's counsel's questioning is inaccurate, and 2, Reed's counsel extended Proctor the courtesy of delaying the start of the deposition for 2.5 hours to accommodate Proctor's stated needs and should not now be punished for that as Proctor requests. I wonder if the request was to tread lightly into some of these things because they were trying to get anything on the record. And perhaps, and there might be reason for this as well, because we don't have all the information. It might be that Proctor's lawyers were like, hey, can you tread lightly? And Reed's lawyers were like, okay, we're going to tread lightly and get everything we need before we get into the heart of the investigation. Because if we don't get that and we get to the investigation and something happens and the plug gets pulled, then we're never going to get back to that information. So maybe it was an inverse of we're going to get to the heaviest stuff at the end because he says that he's kind of teetering on whether or not he's going to be able to do this deposition. We've already delayed it 2.5 hours. There might be strategy to that as well, that you kind of leave it for the very end. So if everything explodes, at least you got everything else you needed. Sure. Proctor's description of Reed's counsel's questioning is inaccurate. Reed's counsel extended Proctor the courtesy of delaying the start of his deposition 2.5 hours to accommodate Proctor's stated needs and should now not be punished for that as Proctor requests. Finally, Proctor's statement that Reed's counsel, quote, has continued to state that they will not provide assurances regarding the use of deposition transcripts and recordings is false. Reed's counsel has repeatedly and consistently, including in a 9C conversation yesterday with Proctor's counsel, stated that Reed will agree to the restrictions Proctor's counsel requested if all parties to the case agree to them. That's not unreasonable to me. That's not unreasonable to me at all. Why should they be the only ones that agree to it? Everyone present at the deposition should agree. That's not unreasonable to me. Sure, fine. Why would anyone have a problem with that? I don't see the lawyers from the waterfall being like, no. So who's having a problem? Emails evidencing Reed's attempts to obtain all parties' agreement have been previously filed with the court. Plaintiffs have refused to respond to Reed's proposal, which mirrors Proctor's. Really? The O'Keefe parties are like, no. Or is it just now that lead counsel for plaintiffs just doesn't want to respond to Reed's emails? They have gotten themselves into an untenable working situation here, where it's beginning to feel like if Reed's attorneys are like, hey, ABC, the other lawyers are like, no. And then if some other lawyer was like, hey, ABC, the parties would be like, yeah, okay. going to need a coffee maker in my office for the amount of coffee that this is going to take. All right. Reed respectfully requests that the court reconsider its order. Let's go see what the court does, and then we're going to go to the hearing. Look, these motions are getting us nowhere because everything is just a little bit spun. And I think that Reed's attorneys, even though they might not see the issue, here's the issue as I see it. Reed's attorneys leaving off the panic attack in the hallway, I think they could have added the rest of the tweet into what they quoted and addressed it more. It seems like they are sidestepping that part. I don't think they needed to, because if you have people being like, I saw it on the security camera, it seems that there's information that's out there from inside the building, but not inside the deposition room. And I think they should have addressed it. So that's my thoughts on that. I think they should have addressed it more. And I think it was fairly restrained for them to say that the description of the questioning is inaccurate. I think they could have explained it more. I don't know if that would have helped with the court. So let's see what the court says. That was filed on July 9th, 2026. Some of you, if you see that this said it was more pages, this was signed by Rosenberg. A couple of you asked. This is one of the motions where the court system populated like 3 or 4 duplicates of it when it filed. I don't know why. It's happened a couple times and it ends up with so many pages, but it's just the same motion, all pages, like 4 times. Wild. Let's go see what the court said, shall we? All right. First, I'm going to look at the docket, and I don't see any letters on the docket. Some of you mentioned in the chat that those things were on the docket. Those letters were on the docket and then came off the docket. I will go look for those. If that's true, they're probably existing round and about the interwebs. I'll go look for them after stream. But there aren't any on the docket that I see right now. So I went and looked for those letters because I'm not surprised that Proctor's attorney were like, hey, this is being said on the internet. Because it seems like they have a full-time law clerk just scouring the internet for information. Okay. Let's look at what the court said before we go to this hearing on July 10th. Because the court made this order on July 10th. I do not know if this order was given to the attorneys before or after the hearing. We're reading it now because, well, I would love to close this loop. I would love nothing more than to close this loop. Did I put the wrong link in my notes? Yes, I sure did. That's okay. We have it in 2 places. Give me 1 second to grab that. And then we're going to take a look at the hearing from July 10th. Once I find the court's endorsement order on this in my vast filings in this case, because they do not stop ever. And when I say endorsement order, it is because the court writes the endorsement on the page. So it's the front page of the motion with the court's notes on it. Not all jurisdictions do it. Massachusetts is one of the jurisdictions that does it. At least this one's not written up the side. The court actually wrote it in the blank space, baby. And I'll write your name. The court wrote it in the blank space at the bottom instead of all up the side. So at least we can read it a little bit better. It is in like 9-point font. So I'm going to zoom in and we'll have to move back and forth as we cut off some of the sentence. July 10th, 2026. This is the court's endorsement order. I have been presented with a motion for reconsideration of my order precluding further attempts to take discovery from a non-party pending further orders of the court. An opposition and a reply. Ms. Reed's attorneys are reminded Ms. Reed's attorneys are reminded, the court says, of the provisions of Superior Court Rule 9A-A3 that a reply memorandum is to be limited to matters raised in the opposition which were not and could not have been anticipated and addressed in the moving party's initial memorandum. Your Honor, that's bullshit. Can we just call this what it is? That's bullshit. Here's why it's bullshit to me. It's how could they have anticipated that the court, how could they have anticipated that the argument would be relating to June 25th when the court's order was clearly relating to June 8th? So they responded in their reply to what was brought up in the opposition. I don't think they could have reasonably anticipated that, because they're asking the court to reconsider the order. Let's logic this through real quick. Reed's party asked the court to reconsider the order made to stay Proctor's discovery. The court said that that was being stayed because of the June 8th tweet that the court said came out 30 minutes after Proctor's attorneys sent impounded material to court and counsel via email. If they had brought up June 25th in their motion, the court would say that it's not related. That's kind of a damned if you do, damned if you don't. Ms. Reed's attorneys are reminded that a reply may only include things that were not anticipated. How would they anticipate the moving of the goalposts to a completely different day and unrelated items? Huh? I mean, I had critiques of the reply, but my critiques weren't that the reply wasn't directly addressing the opposition. The opposition went completely left from what the motion said. It just do not pass go, do not collect $200, skip over the point that they made and argue something completely different. Okay, sure. The motion misstates what I said. Your Honor would like to have the last word. Your Honor would like to have the last word. And the last word is what, Your Honor? The motion misstates what I said. What I said was, I'm reading this directly. What I said was, orders of the court have been violated either directly or at the very least in spirit. I did not say what is stated in the motion, quote, that an attorney with an appearance in the case, quote, had violated the letter or the spirit of the rule. I do think that the court connected that to an attorney with an appearance on the case. But I do think that the court's direct statement was regarding the court order, not the rule. I also did not state on the record that, quote, I had stayed the second day of Proctor's deposition, but rather stated that, quote, because the disclosure of sensitive private information, I temporarily stayed further discovery of a non-party. I agree that that's what the court said, but the impact of what the court said, the practical effect of what the court said, was to stay the second day of the deposition. Did they say that the court said that he stayed the deposition? I don't think they quoted that the court said, I'm staying the deposition. I think they stated that that was the impact of it. Oh my God. Oh my God. Was it in quotes? Now I need to know. I need to know if it was in quotes. We're going back to Reed's motion. I have to know if it was in quotes or not. That's not what I said. Okay, but that's what happened. Let's see. I'm control effing through this motion. Oh, I can't OCR the motion. That's really annoying. Oh my God. The way that Massachusetts scans these in makes it very hard to seek and destroy. All right. There will be no control effing. We're going to look for ourselves real quick. Good thing our brains work fast. Let's see. The court stated on the record that it stayed the second day of Proctor's deposition because an attorney with an appearance in the case had, quote, violated either the letter or the spirit of the rule. That's why the court's taking issue with it. Because that's not what the court said on the record. That is the impact of the court's ruling. Okay. And that's why the court's mad. The court's like, that's not what I said. The court's not wrong. That's not what the court said. Is it splitting hairs? Yes. The impact of the court's order, and that's what they wanted the lawyers to do. They wanted the lawyers to say, the court stated that all discovery as to former Trooper Michael Proctor was stayed because of this. The impact of that is this. Right, because that's not exactly what the court said. The court stated on the record. Well, they said it, and the court's like, The court is now citing, I know you are, versus, but what am I? Okay. The impact is the same. The court's back here fighting with words have to mean something. And yet, we're not mad that the opposition of the motion doesn't directly respond to the motion at all. We're cool with that. Let's see what else the court has to say. The court, I didn't say that. I didn't say that. You stayed all the discovery. The court says that the court said, quote, because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. Now, the court is putting that in direct quotes, and that's not the direct quote either. Because I think the direct quote was, I am temporarily staying further discovery of the non-party until further order of this court. So I don't think the court quoted the court correctly. Oh my God, you guys. The court goes on to say, I acknowledge the information in the motion as of the time of I acknowledge the information in the motion as to the time of June 8th, 2026 post on X. I'm going to read that again and make sure it's not my dyslexia and it's actually this sentence. Because what is this sentence? I acknowledge the information in the motion as to the time of a June 8th, 2026 post on X. Is that the court acknowledging that they're wrong then? Because it seems like the court is acknowledging that the timing of those Twitter posts were incorrect. It's a terrible sentence, but it seems that both the court and Proctor's attorney are having a really hard time with the simple sentence of the timing on that tweet is wrong. It happened before the information. It raises concerns as to how people know this information. Everybody is really having a hard time just spitting out no. The defense is wrong. Y'all, what are we doing? My cousin Vinny is what I was just doing. The court goes on to say, however, a couple of you are saying the court is using ChatGPT. No, I think the court is writing this while frustrated. It's giving hasty. There is nothing about what the court is doing that seems thoughtful. It's very reactive, which is not what I want to see from judges. It's their job not to be reactive. The court says, however, such information does not allay the concerns that gave rise to the order, especially given the content of a June 25th, 2026 post on X. The motion for reconsideration is denied. So the court moved the goalposts. Oh my God. That's so annoying. So where are we at now? Well, the court moved the goalposts. So on June 10th, we get to the end of the court's snarky endorsement order. And the court says in a incredibly poorly worded sentence that is unclear, like, keep it simple, y'all, keep it simple with the clear. But the court acknowledges the timing of the June 8th tweets, but then goes on to say that it doesn't matter. However, the court is still concerned because of a June 25th, 2026 post on X from Turtle Boy. And because of that, the court denies the emergency motion. What does that mean, Emily? Well, it means that discovery as to former trooper Michael Proctor is still stayed because of things that Turtle Boy said on Twitter that Karen Reed's attorneys have come into court and said, but this doesn't relate to us. And the court's like, I don't care. I have concerns. Denied, counsel. So did Proctor's June 14th deposition go forward? I would suspect not, based on all of this, because the court's stay is still in place and the court denied the motion. So Karen Reed's attorneys came in and said, Your Honor, look, you had concerns that sensitive information was disseminated. The tweet came before the information was sent to the court or counsel. So can we please lift that stay? And the court said, yes. I see that. But it does not allay my concerns because now there's this additional June 25th post regarding Proctor's deposition. And Reed's attorneys came in their reply and said, yes, but this is the information that was on social media. And the court said, denied. What can the attorneys do about that? Not a lot. Because the discovery deadline's coming up. And Proctor, at this point, was not made to go to an additional sitting for his deposition. So, Emily, let's break this all the way down. Yeah. So, Proctor made an emergency motion the Friday before a Monday morning deposition. Yes. And he said, whoops-a-doodle, I can't come to my deposition on Monday. We need an emergency hearing. And the court had an emergency hearing, punted till the end of the day. The entire day Proctor was supposed to be deposed, got eaten up by the court saying, I'm going to need more information. And then the court said, your information is still not sufficient. Go to deposition tomorrow. And all the attorneys said, we're going to have to continue it to a different day. And the court was like, why can't you do the deposition tomorrow? Every time they come into the court's like, what depositions do you have? When are they getting done? Why aren't there more depositions getting done? And then every time they come before the court saying, can you make a deposition happen? The court goes, no. So then Reed's attorneys are like, can you please reconsider this? Your concerns were a June 8th tweet. We've shown you that that tweet was not made at the time that you thought that it was. Can you please lift this stay so we can do Proctor's deposition on July 14th, 2026? And on July 10th, the judge said, no. Because even though I acknowledge that the June 8th issue is not an issue, the spirit of my concern still lives, as shown by a tweet on June 25th. Which Reed's team came in and said, but there is sources outside of this that show that that's not true. And the court's like, I have concerns. No Proctor deposition. And the frustrating thing about all of this is that Proctor is going to be deposed in the federal case. Why are we pretending that all of these hoops are not going to just loop back round to Proctor being deposed in the federal case? It's not as if we are doing anything other than continuing to kick the can down the road. And when the court finally puts his foot down, the court has also shifted the goalpost to another thing, which seems to me to indicate that the court believes in some way that Reed's attorneys are sharing information. That's the vibes on my end. The problem is that the court has not directly said that. And so there's no way to really rebut something that isn't said, but seems to be an underlying current in this case, is that the court is suspicious. And the court seems to have concerns, but won't let anybody share the information about the concerns. And then when they do, the court's like, it's not enough. So what do you do? And a lot of you are asking me, can they appeal it? Courts have wide latitude when it comes to discovery. So I don't think an appeal will help. And this judge is also the judge that this was signed July 10th, that they had to go before on July 14th, also yesterday. How are they going to do all that on the 14th? Because the motions to dismiss were also being heard on the 14th before this judge. So what do you do? It's clear that Reed's attorneys in their filings have not backed off ruffling the judge's feathers, and that they are all now locked in horns. I don't know how they unwind it, but it is frustrating to watch the moving of the goalposts, especially when we don't see anything else on the docket today that addressed the other concerns of the tweets. The amount of energy that is going into what somebody said on Twitter is substantial. Really substantial. So, where do we go from here? Well, the court had a lot to say on July 10th. And I think that it makes the most sense for me to cover the court's other orders and then go to court. So let's do that first, because there are 3 other orders from July 10th, and then we're going to go to court July 10th. Sound good? Let's do that. All right. I'm kind of buffering. The snark about the reply has to address things that you couldn't have anticipated. Does the judge think that they should have anticipated that the parties would raise the other date? It seems to be that the court believes that is what should have been addressed. But I think that if they had, the court would have said, but this isn't what my motion was based on. The moving goalposts from the court is particularly disappointing, because it feels like we're just going on vibes. And it's the law. We're not, if nothing's concrete, how can anything get done? All right. This would make me crazy. Emily, how did you know civil law wasn't for you? This kind of shit. This would make me crazy. Joanne asked in the chat, what federal case? Karen Reed suing Proctor, Buchanan, Tully, and the House defendants for deprivation of rights, among other things, is in federal court. So in the Karen Reed multiverse, there is the wrongful death case, wherein there are filings like daily. There is the Karen Reed federal case, which is Karen Reed suing everybody for deprivation of rights and more. Then there is the defamation case where those in the House are suing Karen Reed and Turtle Boy. Then there is the Karen Reed suing Canton and MSP. Then there is also Karen Reed interceding in that group of 5 criminal cases that are having Proctor problems. So many Proctor problems. July 10th. Order relative to docketing. Emily, I thought we reviewed this already. No, we didn't. We reviewed a different order from the court that was relative to filings, not docketing. I know. Emily, how do we keep it straight? I don't know. Didn't the court already kind of say this? Yes. What is this? An order relative to docketing. Let's take a look. The quote, notice pleading e-filed on July 9th, 2026 at 3:46 p.m. by Miss Reed's attorneys shall not be docketed. What the fuck got filed? Damn it. The Superior Court rules include limited opportunity for the filing of, quote, notice type pleadings, CEG Rule 9D, relative to motions seeking reconsideration of decisions made pursuant to Massachusetts Rule of Civil Procedure 58B, 52B, 59B, 59E, or 60B. You sunk my battleship. And then in parentheses, moving party shall also simultaneously file and serve a notice of motion for reconsideration in the same manner as provided in the final sentence of Rule 9E and Rule 9E relative to motions to dismiss. And then within a paren, a party must also file with the court a simple notice of motion to dismiss. Okay. The parties should refrain from filing such, quote, notice type pleadings unless they are required under applicable rules or are requested by me. Parentheses. On July 1st, I did encourage the attorneys to confer and to seek to reach an agreement, and I further stated that in the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. In my July 6, 2026 order, paper number 152, I stated that if no such agreement was filed before 4:30 p.m. on July 9th, I would issue further orders I deemed appropriate. I did not request to be notified as to the progress of discussions between counsel. Your Honor, I think we can guess at what the filings were about based on the other filings we've read, because in the other filings, Reed's attorneys said that they had reached out to all the attorneys to try to reach an agreement. It sounds like they filed a notice to the court saying we have been trying to reach an agreement and we haven't. And the court's like, whatever. I don't want to hear it. I told you to file an agreement, and if you don't have an agreement, I'm making one. I don't give a shit if they won't answer your emails. Don't talk to me. Okay. I did not request to be notified as to the progress of discussions between counsel. Period. I also questioned seeking to put the emails relative to communications from various counsel on such issue on the docket. I see. So the court does not want the docket used as a way for the attorneys to slap at one another. Too late. And believes that including all of the emails back and forth from counsel would serve no other purpose than for the attorneys to say, well, they won't respond. We're trying to come to an agreement and they won't respond, which I'm speculating about based on what Reed's attorney said in the other motion. So basically, Emily, what is the court saying? The court is saying that Reed's team filed a notice pleading, which was just giving the court a heads up on conversations that the attorneys were having. He didn't ask for that. Reach an agreement and file it, or don't. But do not put all of this information on the public docket that I didn't ask for. The public docket is not to be used as a way to, and I'm quoting a little bit of the federal rule on this, but that the docket is not to be used to generate headlines, information. It's not to be used to just air grievances. And we've seen federal judges clap back on that. However, I do not find this consistent for this judge with every hearing. Well, where are we at with this? And where are we at with that? And where are we at with this? So you file this on a Monday and he might be like, oh, okay, you tried to reach an agreement and you didn't. You file it on a Wednesday and he's like, why the fuck are you giving this to me? It's frustrating because all of a sudden now it's just like, me. Okay. So the court doesn't want the emails and the filings and said, don't do that. So the court's just telling Reed's attorneys, don't do that. Like, stop it. Literally, that's what the court's saying. Stop it. All of you stop it. Okay. So I guess the attorneys didn't reach agreement. But in the past, the court has asked for all of the emails. So I guess they're going to keep just guessing at what the court wants and being like, oh, okay. So you wanted this yesterday, but today, no. What'll it be tomorrow? Like, I have been critical of judges in a variety of ways. And one of the things I've said every single time and will always say is, even if I disagree with the way a judge interprets the law on a certain area, I will take a consistent judge over an inconsistent judge any day of the week. Consistency is key. Inconsistency is and can be so gamified that you just have no idea what's happening. All right. I agree. Pippa Aura Legal 2019 said, consult the Magic 8 Ball before filing. Yeah, they all need a Mystic Pickle. Mystic Pickle!
As your best friend, I think you should consider other ideas.
I don't think I pushed the button, Mystic Pickle. I just picked it up. I don't know why it's talking to me. We didn't even ask a question, but thank you, Mystic Pickle. They need a Mystic Pickle. Do not start sending the lawyers Mystic Pickles. They can get their own Mystic Pickle. But I was just going to ask the Mystic Pickle if former Trooper Michael Proctor's deposition in the wrongful death case is ever going to take place, Mystic Pickle.
Today, tomorrow, maybe someday.
Maybe someday. Maybe someday. Thanks, Mystic Pickle. Great. Apparently they need a Mystic Pickle before filing anything, because the Mystic Pickle is like, maybe someday is your answer. Fantastic. I don't think Mystic Pickle is wrong. All right. Oh, we did this motion. Yep, we did this order. Okay. What is our next order from the court? Disorder. You know what soundbite we need is disrespect your surroundings, because that's where I'm at right now. There's nothing else. All right. On July 10th, the court also filed the proposed discovery order, and then we're going to the hearing. Let's take a look at this proposed discovery hearing or proposed discovery order first. This is so frustrating. July 10th, proposed discovery order. On July 1st, I invited counsel to come to an agreement to hold private personal information in confidence. On July 6th, I stated that if no such agreement is filed before 4:30 p.m. on July 9th, I would issue further orders as I deem appropriate. I added the as. I would issue further orders I deem appropriate. Prior to issuing any such order, I invite the parties to provide comments on the following draft language. So you filed an order telling Karen Reed's attorneys that you didn't want any conversation regarding their conversations about trying to come to an agreement about this language. And then you file an order saying, I invite all the attorneys to comment on the language that I propose. Okay. I invite the parties to provide comments on the following draft language. Quote, deposition testimony taken in this matter in the form of video or audio recordings or written transcripts, including private personal medical information learned at any such deposition or through discovery, shall not be disseminated and shall only be used for the purposes of this case or McCabe versus Reed. That's the defamation case. Each party is requested to provide written comments, 1 page and no more, in parentheses, to the above. So to the court, to the above on or before 3 p.m. on Monday, July 13th, 2026. As to other pending actions, although the parties to any related matter are free to agree to such limitations, I will not enter an order in a matter not assigned to me. Well, you don't have the authority to. Okay. Okay. Ashley Oakes asks, what about the federal case? This court has no authority in the federal court and can do nothing about that. And will not, this judge, Judge Gildea, Judge G, only has the defamation case, which is House defendants versus Karen Reed and Turtle Boy, and the wrongful death case. The Karen Reed suing everybody is in federal court. Nothing this judge does has any impact there. And the Karen Reed versus MSP in Canton is in a different jurisdiction. This court does not have authority there. This court can limit the use to these 2 cases. And then if the parties want to expand that use, they would have to come to this court and be like, Your Honor, may we please have permission to use this in this other case? Just like we saw with Proctor's texts. We saw the parties going into court in the criminal cases saying, can we please use the Proctor text in these other cases? Okay. Now, with all of that, we can get to the hearing on July 10th, and then we will take a look at the attorney's responses herein. Never have I been more glad that during this hearing, I have a chocolate croissant on my desk, because I don't think I'm hangry. I think I'm just annoyed with these lawyers. But either way, this croissant's going to make it better. Do I have my notepad? Okay. We need my notebook. I remembered to bring it in. It had just traveled with me. We have our super note. We have a pen. I have not watched this hearing. We're going to court. Thank you, Team Baker, for grabbing this while I was traveling. I appreciate it. Holy shit. I'm so concerned. Because this is just, it's so frustrating to watch all of this unfold. What are we doing? I just want consistency of the court. Your Honor, just consistency. That's it. Just consistency. That's all. We just look. If this level of hyperbole is not helpful, the court is feeding that in the way that the court is engaging back. And it just keeps raising the temperature. It is the court's job to bring things to order. And it is not lost on me that the court wanted to talk about everything being made a spectacle while the court continues to fan the flames of a spectacle. Okay. Sure. Your Honor, I suggest maybe a concert, Your Honor. We need to kind of realign the chakras. Like the vibes are off. The vibes are off. So I don't know if we need like a concert or like the courthouse needs an exorcism. I don't know, but the vibes are off. Can we fix it? I have a lot of sage in my garden. I'm happy to dry it and send some. Like, I don't know what we need at this point, but we need something. We need something. Maybe he does. Maybe he just needs a Snickers. Let's go to court. This is from July 10th. Let me make sure that we have the right date here so it's not confusing. Thank you, Law Nerds, for whoever invariably comes in and is like, didn't this already happen? Yes, this is from July 10th. I haven't seen it. I have been traveling. Okay. I mean, at this point, it's not us. It's wild to watch unfold. Let's go to court, shall we? All right. Your Honor, we are back in court together in Massachusetts on July 10th, 2026 for a continued hearing on the motion to compel Colin Albert's deposition. I need to do a road so far. We are back in court July 10th for the court's continued hearing on Karen Reed's motion to compel Colin Albert's deposition. Remember that the court already issued part of a ruling on this, and the part of the ruling was, I'm not compelling the deposition yet because I need to know when Colin Albert is available. And we have heard multiple different things from the attorneys for Colin Albert. From two different attorneys, we have heard two different things. And the court wanted more information about how Colin Albert would be available for a deposition, given that he is either at some type of a 3-week school before basic training or at basic training. We've heard both. So we'll see. The court also said that the scope of document discovery needed to narrow down. And in the court's order, the court specifically narrowed down the scope of that document discovery. So the court said, I'm not waiting for you guys to go back and forth and back and forth. I'm narrowing down the scope of discovery. And in the order, the court did that and narrowed it down. It was broader in time than what Colin Albert's attorneys had asked for, but it was more narrow in scope than what Reed's attorneys had asked for. So, does that change the fact that Colin Albert is still a party in the defamation lawsuit and the breadth of discovery will be greater as to Colin Albert as a party in that lawsuit because he's a plaintiff than it will in this case? Yes. So, Emily, the practical effect of this is what? That the court is limiting it down when he is a third-party witness and the scope of discovery can be expanded when he is a plaintiff. Yes. To all of you in the chat that just pointed out, and I saw, who did I see pointed out? Because I wanted to say thank you. I lost it. I'm sorry. But to everyone who pointed out that we have not flown to Massachusetts yet, thank you. Thank you. Thank you. Your comment is absolutely correct. Caught my attention, and we did not fly yet to Massachusetts. We're getting the stormy weather flight today. Buckle up for turbulence. Emily, is that why you didn't get home on Sunday? Yes. Because I got a text message from Delta that was like, hey, girl. It didn't say that exactly. Your flight's delayed by 34 minutes. And I was like, oh, okay, no big deal. And then it was, hey, your flight's delayed by another like 48 minutes. And I was like, that's oddly specific, but okay. And it was like, hey, your flight's delayed by another 120 minutes. And I was like, what? Boop, boop, boop. Hey, Delta, I have a connecting flight. They're like, oh yeah, that's not happening. There's a full ground stoppage in Atlanta. I'm like, lovely. So if my flight's this delayed and I get to Atlanta at the time I'm supposed to get to Atlanta, then what? There's a flight in the morning. Oh, okay. What I'm not doing is flying into Atlanta during ground stopped weather to either try to drive home at whatever time it is with a rental car that I may or may not be able to get because whatever time it may or may not be, or to try to find a hotel in Atlanta at whatever time of night it may be to get up for a 6 a.m. flight in Atlanta, or to sleep in the airport. We're not doing any of that. Hey, can I just get a flight out in the morning? Can I just do that? Can I just get a flight out in the morning? And Delta's like, yeah, you can absolutely do that. Thanks. So you'll just be crediting the overnight stay back to the back to me then? Yeah. Okay. I'll take a flight in the morning. So then the hotel that I was in, the one with the fire alarm, story for another day, but the hotel I was in, I just called the front desk. I was like, hey. And at this point, I'm like, it's Sunday night. I had a late checkout. Hey, hotel that I'm in, can I just extend for a night? I'm leaving at like 5 o'clock tomorrow morning. We're full. Wonderful. That's wonderful. However, there were plenty of other hotels in the area, and there's a Kura near where I was, and I was able to change hotels and get some sleep and get up at 3 o'clock in the morning to catch a very early flight and then get home. I know they're never full. I was like, they said they were full. They're like, no, we have no capacity. I'm like, seriously? I just want to sleep. I just want to take a shower and lay down. Also, Kid said, why not? Sleeping in the airport is always an adventure. Kid Muggan, I am down for an adventure. However, my age has reached the digits where sleeping even in an unfamiliar bed might cause my neck and my back to not operate for like 5 to 12 business days. So unfortunately, I am at the age where I do not do well either sitting up all day or trying to sleep in the airport because my back is old. I have reached the age where I am unfortunately too old. When I was younger, I didn't mind at all. I'm like down for whatever. I have reached the age where I cannot adventure in that way. When I did like 3 days of a modicum of following Travis around on tour, and I am going to be tired for a month and a half because it is so intense what they are doing. And I'm like, I can't. So nope. I was like, I will just stay put. Also, I get very motion sick. So when there's a full ground stoppage in Atlanta and a bunch of spicy weather, I'm just staying put. I'm staying put. I'm staying put because, I get motion sick on a good day. So I'm sure everyone is, appropriately appreciative. And then getting home the next day was pretty smooth. So fingers crossed for next travels. But yes, I am unfortunately not down to the type of adventure anymore. And what I have found, let me know if this happens to you too. Motion sickness for me is worse if I am extremely tired or dehydrated. So not getting adequate sleep just makes everything more miserable, unfortunately. I mean, then again, not getting enough sleep really does limit and impair function. So, yeah, I need to sleep. There are the minute suites in Atlanta. I did not look and see what that looks like, but that's a good reminder because I've never used them. And also when stressed, trying to decide new things and come up with an alternate plan was stressful. So I'm like, I'm staying put. I'm staying put. That was about all I could handle. All right, everybody. Are we ready? Are we ready to go? Let's go. All right. July 10th. I have to make a note about the minute suites. It's a very good call. All right. Ready? Let's go.
Colin Albert.
Is this, I want to make sure I'm at the very beginning. Yes, we are. Okay. Colin Albert.
To Mr. Colin Albert. And I had indicated at that time, I thought it would be a great idea if more information was found out. So let's first hear from...
Yes, Your Honor. You have taken a motion to compel and you have extended it. You have extended it to the extreme nth degree. So let's see what the lawyers have to say.
Attorney Tuxbury relative to the information about Mr.
Tuxbury's
Colin
back.
Albert.
Certainly, Your Honor. I read this, so I apologize having to read it down. What Mr. Attorney Maddie did. So prior to the hearing,
Attorney Maddie was the one at the last hearing. Tuxbury was the one at the first hearing. So these are the two attorneys that we have seen.
he had contacted the base asking about the inquiry we discussed on the hearing June 22nd. On June 23rd, he received a call from a private Jordan Rosa in the legal service department at Fort Jackson.
Why didn't you
And
just
he indicated
file
he was
this?
returning a call to place last week. He made the request to Private Rosa about getting access to Mr.
Okay.
Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training. So the 10-week basic training, the first 3 weeks was the initial school. He's past that. He's now in basic training at Fort Jackson. Private Rosa indicated...
Chad, I'm sorry. Somebody is flipping their papers on top of a microphone. I don't know who is doing it. It is annoying to me as well. There is nothing I can do. However, what we are learning now is that the information we got at the last hearing was that he was in basic training. But now we're hearing that at the last hearing, he wasn't in basic training. He was in whatever the 3-week school is before basic training. And now he's in basic training. But the last attorney at the last hearing said that he was in basic training. These seem to be two very distinct things. Why is the court not worried about this? It seems like there was a 3-week pre-basic training and then basic training. And if that's the case, then couldn't there have been a break in between the two before he started basic training? It seems like that might have been possible. But the attorneys are just like, oh, well, last hearing, the attorney said he was in basic training, and now we're hearing he's not. He's now in basic training. So we have now kicked the can down the road enough that he is now in basic training. All right, I'm backing this up.
About getting access to Mr. Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training. So the 10-week basic.
He wasn't in basic training then when your colleague said that he was, and he is in basic training now. This is fair. Doctor Who said, Emily, normally no, once you are deemed ready for basic training, they'll start immediately. That's fair, but it seemed like if this thing was happening, then that might have been able to just squish into the middle of this. And the attorneys just keep saying different shit, which also frustrates me.
To Private Rosa about getting access to Mr. Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training.
Now.
So the 10-week basic training, the first 3 weeks was the initial school. He's past that. He's now in basic training at Fort Jackson. Private Rosa indicated that he was unaware of what process it would have. On June 26, 2026, Attorney Maddie received a call from Sergeant Lucas Vaughn at the Trial Defense Services in Fort Jackson. He indicated he asked about getting access to him from basic training for purpose of a subpoena. He was told, quote, "That's not happening," is what the sergeant said. He
really curious how the question was phrased to the sergeant that said, that's not happening. I'm really curious what information was shared with the sergeant.
Speculated that the only possibility would be a 30-minute phone call. He said that the training regimen for basic training is very specific and condensed. He advised that eating and sleeping are the only breaks that the trainees receive. He said that following his graduation from basic training to advanced infantry training, which is what he's doing, he'll be a permanent party member at a duty station.
So he said following basic, he has advanced equipment training. Hold on. I just realized that my closed caption's not on. Give me 1 second and let me make sure that that goes back on. Sorry about that, chat. There we go. That should pop back up. But it sounded like he said after basic training, then he has 3 weeks additional training.
He said that following his graduation from basic training to advanced infantry training, which is what he's doing.
I couldn't hear what advanced something training. I'm not sure exactly what the word was. Some of you are saying advanced individual training. Thank you, chat.
He'll be a permanent party member at a duty station. He's more likely to have access for a deposition at that time. On June 26th, Attorney Mandy received a correspondence from Colonel Jacqueline DeGain, basically suggesting that he would need the identity of Colin's commanding officer. We've now made several requests of Colonel DeGain for the identity of a commanding officer. Those have so far gone unanswered. So that's the current state now. We've had several calls with a private sergeant colonel. So far, don't have the information. It's been suggested to us that during basic training, they control their life from waking up to going to bed. That, like I said, the only breaks they get are sleeping and eating. And it's part of the turning.
I'm sure at some point they go to the bathroom, but right. And chat, I do not have a problem with Colin Albert joining the military. That's not my problem. My problem is the way that the lawyers have communicated things to the court. And I am concerned about the way that the lawyers communicated things to Colin Albert. I'm concerned that in this game of telephone, what we are seeing coming out in court is not all of the information. And I am also concerned about how Colin Albert can go forward as a plaintiff in another case if he is just not available. Fine. If he is just not available, then don't be a plaintiff in the other case, or enlist 4 or 5 months down the road. So the timing is concerning, just based on everything that's going on. The communications that the lawyers are presenting back is concerning, and all of it is just kind of a mess in the way it's being communicated to the court in such a wild cluster. So here we are in kind of a wild cluster of cluster. And the way that the lawyers are communicating it to the court feels less than transparent. And I don't know if that's because the lawyers don't know what's going on. I don't know if that's because the lawyers have strategically asked less questions because they want plausible deniability. Something is off. I don't know what it is. But the transparency is lacking. So he's in pre-basic training. No, he's in basic training. No, he was in pre-basic training. Now he's in basic training. Does no one know what's going on? And the court is just like, meh. Okay.
Into a soldier. So that's the kind of information we have. It's been suggested to us that during basic training, they control their life from waking up to going to bed. That, like I said, the only breaks they get are sleeping and eating. And it's part of the turning them into a soldier. So that's the kind of information we have now. I believe he's in week 2 or 3 of basic training.
Okay, thank you. Attorney Seligson, is that news to you? Or have you had communications with...
I would think it's news to him, because he might not know, because we were preparing this to get, and then
Tuxbury, he's not talking to you. Excuse me, Tuxbury, he's not talking to you. But listen to what Tuxbury's saying. I would think it would be news to them. This hearing's July 10th. What does that mean? That they did not distill this to writing, to email, or anything, and then disclose it to the other side. Okay.
Okay, thank you. Attorney Seligson, is that news to you? Or have you had communications with...
I would think it's news to him, because he might not know, because we were preparing this to get, and then we got the notice about coming today. So I kind of ran today. We had responded on the search terms. We did talk about search terms from Colin Albert.
Okay,
so we haven't had a chance to fill it in.
Why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed...
How is that okay, though? These communications are from the end of June, and the court's like, have you turned this over to the other side? No. Okay, well, why don't you write it down and give it to the other side? Okay. Then why are we here for a hearing today? And he's like, no, I was just preparing to tell you all today. So what, we need to have another hearing then? Just keep kicking it. You should have just emailed.
So I kind of ran today. We had responded on the search terms. We did talk about search terms from Colin Albert.
Okay,
so we haven't had a chance to fill it in.
Why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of that.
So the court doesn't want a response. He's like, write it down, give it to them so they can respond. We can't just respond now. Some of you are commenting on the way the judge's voice sounds. We tried to gain this up a little bit so you could hear the judge. It's been a repeated issue in this courtroom that the judge is so much lower than the attorneys. So Miguelina sound balanced it for us so we could hear. So that's why it sounds like the judge is in a tin can, because otherwise we couldn't hear him. Okay. So the court's like, nah, just write it up and then we'll deal with it later.
Response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of the mechanics of where he is, but we are working productively on the search terms and narrowing the scope of the subpoena.
Okay.
So that's working productively.
All right. Attorney Tuxbury, you're welcome to stay, but on a Friday afternoon, you're welcome to leave, too.
I appreciate that, Your Honor. I think I'll take the invitation to depart. Enjoy the rest of your day, Your Honor. Thank you very much.
Thank you.
And that's the end. So where are we now on the motion to compel the deposition of Colin Albert? Well, they're going to have to continue this conversation later because the court told Colin Albert's attorneys, hey, everything you just told us, put that in writing, give it to the other side, and we'll figure it out. We're just discussing things today. Could have been an email? Yep, could have been an email. And the court's like, all right, we're done with this part. Thanks. We'll see you later. So the court's order, which essentially is not forcing Colin Albert to deposition or not because the court wants more information, is still just waiting and just pushing this further down the road. And the attorneys said that they are working together on narrowing down the search terms, which the court has already ordered in some way. So I imagine there's not much more to do because the court said this is what the search terms are going to be. Okay. So Judge G's like, sure. All right. We'll see you guys later. Have a good Friday. Bye, Mr. Tuxbury. Great. Let's see what happens next.
So the other remaining motion is the plaintiff's motion to compel Ms. Reed to produce additional information and discussion.
Okay. So pause here. The court is now moving on. We're done with the motion to compel or further compel Colin Albert. We are now moving on to plaintiff, the O'Keefe party's motion to compel further answers from Karen Reed. We have seen this motion. Oh, my nose is itchy. We have seen this motion run parallel to some of the other motions. This is the motion where the plaintiffs were like, this motion to compel needs to be heard. This is the same motion where Attorney Rose said, hey, if you had just included me on the email, we would have known that we hadn't responded and we can sort it out. At the last hearing, Karen Reed's attorney said we just turned over responsive information. I don't know if they've had a chance to look at it yet. So we're going to need to come back and see if there's anything else that needs to be finalized. But Attorney Rose had argued that he thought the motion to compel was moot because they had been turning it over. And the response from plaintiff's attorney was, we do not think it's moot and you didn't respond and now you need to respond. And Rose was like, okay, well, put me on the emails. I'm the one dealing with it. So, all right, sure. Continuing on. So let's see what the court has to say about plaintiff's motion to compel discovery or further discovery of Karen Reed.
Discovery. And I've read everything. Mainly the issues relate to medical information and financial documents. And I guess I'll start with Attorney Seligson to ask you, given you know what the standard is, because your office has quoted it a number of times in your motions to compel, that parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action.
It's really broad.
Whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other attorney. Your opposition uses the term fishing expedition, which that's great if it's a criminal case, because that's where fishing expeditions are discouraged.
What?
And not allowed under Rule 17 under the criminal rules. But this is a civil case, and Rule 26 is very broad. So without getting into the specific...
I mean, the civil discovery rules are really broad, but there are still bounds to it. Because, Your Honor, if there weren't boundaries to civil depositions or civil discovery, why would you be footnoting and arguing that Karen Reed's subpoenas were breathtakingly overbroad? Like, you can't say that Karen Reed's subpoena requests are breathtakingly overbroad, which I don't disagree with. I think some of them were way overbroad. But if there's no boundaries, then nothing can be overbroad because there's just no boundaries. Everything's fair game. So So they're saying, Karen Reed's team is saying that the plaintiff's side can't be going on a fishing expedition because, well, it's just open blue water for discovery. But then on the other hand, the court has previously said, well, these subpoenas are all too broad. Also, there can always be a fishing expedition, Your Honor. There are still boundaries for subpoenas. To be fair, let me add a caveat to that. To be fair, the court was talking about overbreadth in the context of third-party deponents, not parties. And in this case, he is talking about parties. I think that's a worthy distinction to make because there are narrower limits as to third parties. But the court's statements don't track for me. So there are different discovery provisions for non-parties versus parties. Karen Reed here is a party, but still, he's like, you called it a fishing expedition, but that only happens in criminal. No, it doesn't. In criminal, you're supposed to turn almost everything over. Okay. Your Honor, your analogy is a miss for me. I don't get it.
It's a criminal case because
I
that's
don't get
where
it.
fishing expeditions are discouraged and not allowed under Rule 17 under the criminal rules. But this is a civil case, and Rule 26 is very broad.
I agree with that.
Without getting into the specifics about the medical, why isn't merely the provisions of Rule 26 applicable here, and why shouldn't they require production of the information the plaintiffs request?
Your Honor, with respect to seeking her medical records for a 2-year period, even though the term fishing expedition generally applies in a criminal case,
I don't agree with that. I don't agree with that. I think the court thinks that, but I don't agree with the court's premise on that. But anything can be a fishing expedition when you're looking for too much information. But okay. Whatever. Emily, you said at the beginning of stream that the lawyers should placate the court more. And now you're looking at the lawyer being like, well, why are you placating the court? I know, because we're watching it in real time. I appreciate that counsel is like, fair, Your Honor, taking your premise. Yes. Emily, isn't that just what you said he should do? Yes, it exactly is. Emily, the inconsistency. I know. I disagree with the court's premise here, but I do appreciate that counsel's like, okay, fine, Your Honor. Even if you're saying this, then this. Fair. But I'm thinking out loud. And I'm just, oh my God. All right. Go ahead, counsel.
Request.
Your Honor, with respect to seeking her medical records for a 2-year period, even though the term fishing expedition generally applies in a criminal case, I don't understand why they would need to understand her health in 2020, 2021.
Yeah, how's that not too broad?
How about 2022?
That's different. Perhaps if they narrowed it, we could reach an agreement about something in confidence. But
Did you have discussions about narrowing it? Did you two have discussions, or were you talking with someone else on these?
I spoke to Attorney Rosenberg.
Okay.
but
Wait.
Hang on.
Because Rosenberg has been dealing with discovery. Right. Okay.
So the next issue relates to the financial documents. And there has been certain information provided. There's been certain information redacted. Have you had discussions about that?
we have had discussions, Judge. The redactions are for transactions that are not specifically asked for in the document request. So what we did was we produced the bank statements and credit card statements for the 2 dates that were asked. We blacked out and redacted account number and private information.
But somewhere you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
So the court moved from medical information. And again, the request of Reed is going to be allowed to be broader than the request of Proctor in this case. Proctor is a third party in this case. Reed is a party. So there is going to be a difference there. Because of that, please keep that in mind. It's going to be different. We have skipped now from the medical question where Seligson was saying this span of time is too broad. We agree that during the relevant time that might not be too broad. And the court just skipped right beyond that and said, okay, let's get to the medical and what's redacted. Seligson is saying, look, we provided what was asked for exactly for the dates that were requested. But if you have a bank statement and 2 dates have been asked for, your bank statement's going to have, 27-ish other days of records potentially? So it's perfectly fine to redact those because that's not responsive. They asked for 2 days. Just because they asked for 2 days doesn't mean they get the whole bank statement. You just redact out all the other days. Well, you didn't ask for that. It's not responsive. Here you go. You don't just give them more than they asked for. It's not a Britney Spears song. We're not in the give me more, give me more. No. We gave them the 2 days they asked for. And now the court is asking about attorney-client privilege. Remember, if you redact something out or if you don't turn something over, you have to cite the privilege that you're claiming to not turn it over. And when we're talking about financial records, paying your lawyers would in fact be attorney-client privilege. So in bank records, that could absolutely happen. Let's see what they say.
In some way, you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
Attorney-client privilege? I don't believe we assert attorney-client privilege, Your Honor. If there is a payment to counsel, then that's what that would pertain to. And if that's reflected on the
Somehow, I don't think counsel were getting paid by credit card at that time. Just a while.
Why not? Why wouldn't counsel be getting paid by credit card? And didn't they say, aren't we talking about bank records? I thought they started talking about bank records and then the court said, I don't think they were getting paid by credit. Do you mind if I back up? Sorry, chat. I thought the court was saying bank records, unless they're talking about both. And they might be talking about both. So I'm just going to back up real quick because I'm curious.
Documents. And there has been certain information provided.
Hold on. Back up to the documents.
That's different. Perhaps
Okay, we're now at the end of the medical records.
if they narrowed it, we could reach an agreement about something in confidence. But
Did you have discussions about narrowing it? Did you two have discussions, or were you talking with someone else on these?
I spoke to Attorney Rosenberg.
Okay.
but
Hang on. So the next issue
A.
relates to
Rose.
the financial documents.
Okay.
And there has been
Financial documents. Helpfully vague. Thank you, Your Honor.
certain information provided. There's been certain information redacted. Have you had discussions about that?
we have had discussions, Judge. The redactions are for transactions that are not specifically asked for in the document request. So what we did was we produced the bank statements and credit card statements for the 2 dates that were asked.
Both.
We blacked out and
Okay, so both.
redacted account number and private information.
But somewhere you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
Attorney-client privilege? I don't believe we assert attorney-client privilege, Your Honor. If there is a payment to counsel, then that's what that would pertain to. And if that's reflected on the
Somehow, I don't think counsel were getting paid by credit card at that time. Just a wild guess.
But there's a bank statement.
Why? Why the unnecessary comments from the bench? Who cares if attorneys are getting paid by credit card or not? I prefer to pay attorneys by credit card. You know why? I want my points. I want my points. I want my rewards points. Attorneys can absolutely be paid by credit card. Okay. Give me my points. All right. Emily, let it go. I know. What are we doing?
As well, Judge. So I don't have it in front of me with all transparency, but that would be the reason for it. The transactions that they asked for on the dates in question, we've given it to them. But just this broad wondering what else is out there and what else my client is spending her money on, it's not relevant, Judge.
I agree with that.
And she's entitled to some privacy on that front.
Right, but again, Rule 26 is so broad, it's not necessarily up to the party to say it's not relevant, because the standard is it might lead to the discovery of admissible evidence.
I'm having a really hard time because it seems that the judge is talking past the attorneys and the judge is saying that, excuse me, I can't, right. The court is saying that the discovery rules are really broad, which I agree, they are fairly broad. But Seligson is saying they asked for these documents regarding these 2 days. And so we turned over the documents with regard to 2 days, and the things we redacted are things they didn't ask for. So it doesn't matter how broad the discovery rules are. They asked for 2 days. We gave them 2 days. The things we redacted were not requested. If you ask for one date or 2 dates, you're allowed to redact the others. And then if anything within that time frame is redacted, then you have to note why it's redacted. And that's where that note about attorney-client privilege would be. However, I feel like Seligson is kind of at a disadvantage in this because the attorney mostly dealing with discovery seems to be Rosenberg. Okay.
That's right.
So they're just talking past one another on this.
Right, but again, Rule 26 is so broad, it's not necessarily up to the party to say it's not relevant, because the standard is it might lead to the discovery of admissible evidence.
It's not
right?
relevant, though. It's Your Honor, you're not hearing the meaning of what they're saying. They're not talking about legal relevance. They're talking about the fact that it's outside the dates asked for. That's it.
If we had a party every time just saying, well, it's not relevant, forget about it.
That's not what they're...
But if they're asking...
Seligson, excuse me, Seligson, you committed the cardinal sin of using, I'm being facetious in this, of using the word relevant instead of responsive. And the judge is stuck on the word relevant instead of responsive. You picked the wrong word. Was the meaning that Seligson was saying clear to me? Yes, it is. But the judge is stuck on the relevancy because it's not relevant to the request, but it's the correct term of art would be it's not responsive to the request. And the judge is just like, you don't get to decide relevance. And he's like, it's not responsive. Okay, fine. It's frustrating because it feels like the court is willfully not hearing what the lawyer says, but I don't necessarily think it's that. I think that the judge is incredibly reactive and he's reacting to the word relevant without hearing the rest of what's being said. And that's been, well, Emily, you asked for the judge to be consistent. That has been consistent. That has been consistent. And this judge does get upset about particular word choice. It is something that has also been consistent. Okay, there's the consistency. The word has made him flustered.
If they're asking for transactions, if they ask for transactions on January 28th and January 29th, and the statement covers January 1st to January 31st, we've redacted out things that aren't specifically asked for.
All right, well, so we'll give Attorney Diller a chance. Do you believe that?
And then anything outside of that window, the 28th and 29th, would be non-responsive.
There was information redacted on the 2 days in question that is relevant.
That's a good question. No, now the judge is using relevant. The word is responsive now, Your Honor. So now the court's asking Diller, Emily just let it play. I know, it really feels like an exercise in watching people who are all saying the same thing in different ways. And the court is not understanding that everybody's saying the same thing in a different way. And the attorneys can't really correct the court on that because he's really not amenable to being corrected in that way. And some of you are asking if this is just this judge. It might just be this judge. This might be the way that this judge has been the entire time he's been on the bench. I don't know this judge. It's easier to get the vibes when you see judges across multiple cases. This might just be the way this judge has always been. It was kind of like Judge, who was always really chatty He wanted to just have a intellectual exploration of like the Magna Carta. He just wanted to chat. And I'm like, what are we doing? It might just be this judge. Imagine having an argument with this judge over breakfast for dinner. I imagine that could go on for ages.
We've redacted out things that aren't specifically asked for.
All right, well, so we'll give Attorney Diller a chance. Do you believe that there was information redacted on the 2 days in question that is relevant?
Emily, you said you weren't going to pause. I was not, but Just Ash 2183 in the chat made an excellent point, more eloquently than I did, and said, Judge definitely does not listen to understand. He listens to reply, and that can cause issues in communication. Just Ash, thank you. You have just put a pin on it better than I did. And I think that's where we're seeing that disconnect, where we see with Judge M's style of communication that Judge M will, if he's not quite sure, will rephrase things to the attorneys. I'm hearing you say this. And Judge M really does seem to try to understand and synthesize the lawyers. This judge seems to just want to fight back with the lawyers. This is a really, thank you, Ash. This is a really excellent point. And it's something that frustrates me beyond just these court interactions. This is something that also frustrates me in human interactions. So when there are things that poke at Emily's, things that ruffle Emily's feathers, the willful or obvious misunderstandings where people are cross-talking each other is one of those things where I'm just like, oh my God, you know, how do you not know what they mean? Your Honor. All right, let's see what Diller has to say. This is a fascinating observation in communication.
Respectfully, I apologize. I don't have that redaction in front of me. I know that as it
Fucking hell.
relates to anything on those 2 days, I believe there should be no redactions, and if things need to get filed, that should be protected. We are amenable to redact.
It's your motion. I think you are right. T-Brained 428 said, I think you need the soundbite of System of Serge saying, disorder. Yes. Diller, it's your motion. Excuse me, Your Honor. I don't have that in front of me. You're the one making a motion to compel answers. Why don't you have the discovery in front of you? It's your motion. Sigh.
All right, well, so we'll give Attorney Diller a chance. Do you believe that there was information redacted on the 2 days in question that is relevant?
Respectfully, I apologize. I don't have that redaction in front of me. I know that.
Why is no one ready?
2 days. I believe there should be no redactions, and if things need to get filed, that should be protected. We are amenable to redacting those
Don't
out.
have it in front of you. I'm sure you have a copy there.
I don't have it in front of me either, Your Honor. It's his motion.
Facts.
My motion is the interrogatory is a separate question from a production of document.
Wait. So, so the court asks Diller about the redactions. And Diller's like, respectfully, Your Honor, like, I was unaware that we had an assignment. Sorry. The court looks at the opposing side and says, you have it in front of you. And Seligson says, I do not. It's their motion. And Seligson's clearly the attorney that's not dealing with discovery because that's Rosenberg. And then the court is like, so Seligson goes, it's his motion. And then Diller says, my motion is about the responses to interrogatories. Okay, but do the interrogatories ask for the documents? What are the interrogatories asking for if not the documents? So the court is the one that's asking about these areas of discovery. And Diller's like, that's not what my motion's about. Okay.
So in the interrogatory still remains unanswered. The production of document is a separate whole issue that we have an outstanding issue for production documents. I acknowledge that there was something that was turned over through production of documents relating to financial transactions. Our request asked them to articulate under oath, every one of the transactions that she had and the institutions that she.
So you're telling me that your interrogatory question was that Karen Reed identify all of her financial transactions in writing instead of just giving you the document? Because it sounds like they just gave you the document and they're like, here's the bank record. No. We wanted it under oath that those were your bank records. Huh?
Filed them for those 2 days so that we can track both her whereabouts and also whether it's reasonably calculated, lead to discovery of it.
Track her whereabouts? What, you want to know how many times she's stopping at the Twice Daily? What? The Wawa, Massachusetts. No, my bad. The Stop and Shop. What do you mean track her whereabouts?
There was something that was turned over through production of documents relating to financial transactions. Our request asked them to articulate under oath, every one of the transactions that she had and the institutions that she filed them for those 2 days so that we can track both her whereabouts and also whether it's reasonably calculated, lead to discovery of admissible evidence, which is significant for just a 2-day period of time.
Okay.
Response to that, Your Honor, as we are entitled to under the rules, we are entitled to say, here are the documents that answer your question with appropriate redactions.
So Diller is saying, and Diller is plaintiff's counsel, O'Keefe parties, said, we've asked for Karen Reed to answer our question under oath, which is interrogatory, sworn, about financial transactions for these 2 days periods. And Seligson is saying, right. So we gave you the financial records for that 2-day period. Because that's the best evidence. Because what would Karen Reed's, let's logic through this. What would Karen Reed's written response say? I've reviewed my bank records and these are the transactions. Because it's going to be coming from the record. So the best evidence is the records, not her reading the record and then saying this is what the record says. Right. Okay.
Response to that, Your Honor, as we are entitled to under the rules, we are entitled to say, here are the documents that answer your question with appropriate redactions for things that are not asked for in the interrogatory.
Okay.
Let's go back to the medical issue for a second.
Why?
Doesn't sound like the two of you have.
Okay. It's just a jump to the left and then a step to the right. We're now going back to the request about the medical records. But we haven't finished this yet. Are we done with this? No? Okay.
Spoken about the medical issues. And you suggested there might be a limited period of time that there could be some agreement on. So I'm going to ask counsel to go talk about it. And I'm going to ask counsel to keep in mind the reference by Mr. Diller to the testimony from the criminal case and the forensic scientist relative to medications. Cited on page, it's in their reply, I think.
Any medications Karen Reed was taking in like the day or two before this, the day of this, would be relevant.
Page 2 of the reply, Your Honor.
So So I'm going to give you a little time to go talk about that. And hopefully you'd also take the time to talk about the other financial records. All right?
Will
If you
do,
can't
Your
do it, you come back, I'll hear you, and I'll issue a decision at some point.
Somebody's phone's going off in court. It's not ours.
Okay?
Okay. Thank
All
you, Your
right,
Honor.
great.
Judge.
Thank you.
So, on plaintiff, the O'Keefe party's motion to compel further responses from Karen Reed, the court asked them about financial documents, medical documents, and if they could narrow it down, and then said that the attorneys go talk about it and figure it out. And then if more information is needed, the court will then take it up. Let's see what happens. Because the court's sending them out to go talk about it. Go talk with each other.
Court, all rise.
Okay. Okay. So they go talk about it?
What other
It's looks like we edited the break out. All right, fantastic. So they went and talked about it, I guess.
at length, what other part
Thank you for saving me the Zoom.
at length, what are the parties asking me to do relative to the motion to compel?
Your Honor, as stated at sidebar, the parties have reached an agreement. We're asking you to table the current motion, for instance, interrogatories for a later date. We'll try to have that all resolved timely.
Okay, court will take no action. Thanks for coming down.
So they went to sidebar before they went back on the record. And they're going to keep working on it.
Motion to compel.
Your Honor, as stated at sidebar, the parties have reached an agreement. We're asking you to table the current motion, for instance, interrogatories for a later date. We'll try to have that all resolved timely.
Okay, court will take no action. Thanks for coming down. We'll see you next week.
Thank you, Judge.
Thank you, Your Honor.
Court, all rise.
So they put a pin in it. They put a pin in it. They put a pin in it. Hey, we can agree on this. We put a pin in it. The problem, as I see it, from what we have witnessed in this case, is that the attorneys on all sides have lost the ability to just navigate these things with one another. The court told the attorneys to navigate these things with one another, and then if they could not be resolved, bring them to the court. And it feels like parties are just unwilling to genuinely communicate with each other until they're before the court. And the court's like, go talk. And they're like, okay, it's resolved. Why couldn't you have done that before? But when the court says go talk, now all of a sudden it can be resolved. If it could be resolved without court action, it could have been resolved over the phone, in my opinion. But no, things keep coming to the court. And with the motion to compel further responses, it's just getting tabled. Great. And what's going on, Emily, with the motion to compel Colin Albert's deposition? Well, the court's put a pin in it, and they will circle back at a later date because the parties had the information at the end of June ahead of the July 10th hearing date, but did not provide it to the other side. So Colin Albert's attorneys did not communicate that information to Karen Reed's attorneys in advance of the hearing. So they got to the hearing, the attorneys got new information for the first time, and then the court said, well, now you need time to respond. So what was achieved in court? It seems that the motion to compel further responses from Karen Reed has been resolved, And more information is still needed regarding Colin Albert. And the court's like, see y'all next week, because they have a hearing on the 16th. Great. Just great. So not a ton was achieved. And the court got very hung up on the difference between relevant and responsive. Fantastic. Okay, we're moving on. We're going to a different hearing. We're gonna do something different. We're gonna swoop to a different hearing. We are going to take a look at, because we are done with the documents we're going over today. I do not think we're going to have time to get to the responses to the court order regarding discovery today, because I am going to run out of time. We are going to go to the hearing instead. The court is going to come up with some type of protective order regarding discovery. We will get to those. I'm not going to have time to get to them today. I'd rather get to the next court hearing. And I think that will be helpful. The next court hearing is from July 13th. This is not within the confines of the wrongful death case. The hearing we are going to now is from the criminal case, where there is still ongoing discovery fights regarding who can access Karen Reed's cell phone and whether she gets her cell phone back or not, and what discovery is being turned over. A lot of you asked about this hearing, so Team Baker grabbed it while I was traveling. I have not taken a look at this, so I do not know. We know there is an ongoing issue here. Excuse me. We know there is an ongoing issue here within the context of the ongoing criminal cases. And we have seen that with regard to an ongoing criminal case with regard to Turtle Boy and the ongoing Proctor problem criminal cases. So we're going to jump into this hearing regarding discovery in a separate criminal action, but for Karen Reed's information. So let's jump into a different courtroom in Massachusetts on a different date. And then when we come back next week, though there will be other things going on in other cases, we are going to need like 2 days, I think, to go over all of the motions to dismiss, because it's quite a lot of information. And we'll do that. Okay. Does that make sense? Chat, everybody's like, yes. A lot of you asked about this hearing, so thank you, chat. Let's see what's going on from Massachusetts Court, July 13th. I'm going to pause this real quick. And we're going to go to a different courtroom. And we grabbed this hearing from the trial channel. I'm glad that they had it up and we were able to grab that. So glad it exists. This is from July 13th. I'm going to change the date and we're going to go to court. All right. We're staying in Massachusetts. We're going to a different hearing. Emily, do you have any idea? Nope. I know it's regarding Karen Reed's cell phone. That's all I know. So different judge, different court, different case, same parties, and ongoing discovery problems. But this isn't criminal. So back to criminal court. This looks like the courtroom that we saw a lot of the Karen Reed criminal hearings in prior to it going to trial.
Next matter does not have a docket number. It's a matter regarding search warrant in the case of Commonwealth of Karen Reed.
Okay. So when the clerk is saying this doesn't have a docket number, it sounds like, and again, this is when we were looking at things for the first time, it sounds like this is outside of, and my summary at the end will probably be better because Emily, keep reading. This is outside of any of the particular criminal cases and regarding a search warrant. Fair. So we talked about this in the context of the Afroman case about what do you do if a criminal case isn't filed and there's a search warrant you have to deal with. Remember, there were search warrants done for Karen Reed that we've heard about in context of the Turtle Boy witness intimidation case where she was never indicted. And we have heard arguments about it, including the day that like all of Karen Reed's attorneys marched into court and Brennan was in court on talking about things. And they were all like, this is about our client too. We should be here. And it's like, this is on another case, right? So this is outside of the context of a specific case regarding a search warrant. And we talked about this in the context of Afroman about if there's a search warrant that is a problem, but you're not charged, what do you do? There aren't a lot of procedural opportunities to go in and deal with it when there's a search warrant, but you're not charged. And so this falls into one of those caveats of there's this search warrant, but what do you do? So here we are. All right. Emily, keep reading. Fantastic.
Good morning, Your Honor. Excuse me. Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth. Good morning.
You got a phone. You got to take it outside the courtroom, please. I'm Mr. Cosgrove. Hi, Mr. Ribos. How are you?
Good afternoon, Your Honor. Attorney Ben Herbalist for Ms. Reed.
Okay.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed's interests.
Good afternoon.
And this is from July 13th. I'm glad it was recorded. All right.
Nice to see you.
Good afternoon, Your Honor. Evan Wolf on behalf of Ms. Reed. Okay. Good afternoon.
I'm kind of excited to see, Emily, are we just being an enthusiast? Look, I am my most comfortable when I just get to be enthusiastic. I want to see people do the right thing and do it well. I'm going to take a minute to be enthusiastic. I am so excited that attorney Evan Wolk is on the record in court because we saw him as a law clerk during the Karen Reed trial, taking care of all of the technology. I'm really excited that now we are getting to see now attorney Wolk on the record in this case, who came into Alan Jackson's firm after graduating, etc. So I'm really excited to see. I'm really excited. I'm like, because he did a fantastic job during Reed Trial 2, running all of the technology. I think it's great. So I'm excited to see him on the record. So yay, Attorney Wolk. Get it. I feel like we've just watched Attorney Wolk just grow up before our eyes. Emily, I know, I'm excited. I'm excited. So I'm cheering on the newer members of our profession. It's great. And he did great work running the technology. I've said he's done great work. So, all right. I was excited. I'm still excited. Everybody wanted to hear the parties. We've got Alan Jackson, Attorney Wolk, Cosgrove, who is a prosecutor, and Judge Doolin.
Phone, you got to take it outside the courtroom, please.
At least it wasn't set to music. I can't say my phone's never gone off in court.
I'm Mr. Cosgrove. Hi, Mr. Ribos. How are you?
Good afternoon, Your Honor. Attorney Ben Herbalist for Ms. Reed.
Okay.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed's interests.
Good afternoon.
Nice to see you.
Good afternoon, Your Honor. Evan Wolf on behalf of Ms. Reed. Okay. Good afternoon. Let me just talk you up and sidebar just for a second.
They go immediately to sidebar. Okay. All right. I zoomed.
Mr. Jackson, the floor is yours. Go right ahead.
Thank you, Your Honor. I appreciate the time and the court accommodating.
It is a beautiful courtroom.
Yes, this morning or this afternoon, I should say, for the purpose of talking about what we filed. I'm going to try not to be repetitive, but I do want to address in no small part, the opposition that the Commonwealth has filed. And really, our motion comes down to a single promise and a single breach of that promise. The promise was independence. That's how we got here. Mr. Cosgrove was appointed on the promise of complete independence from the Norfolk County District Attorney's Office. And on February 19th, in this courtroom, the special prosecutor, I think, slipped and admitted in his own words that the promise had been broken. Everything else in the Commonwealth's opposition, as I read it, is an effort to sort of talk past that fact. And I want to address that in no small part in some order. And I want to start with the standing issue. That's where the Commonwealth leads in their opposition, and I want to lead in my response to that opposition. The Commonwealth's lead argument is basically the conflict. In as much as it might exist, it belongs to Aidan Kearney, not to Karen Reed. It's a clever argument. I can hand it to Mr. Cosgrove for leading with that because it is clever, but it's also wrong. The warrant doesn't exist in the abstract. It exists because the Commonwealth has advanced a theory, a stated theory on the record, that basically Karen Reed potentially engaged in some sort of witness intimidation. That's the foundation for what the Commonwealth has suggested precipitated the warrant in the first place. And it's on the strength of that, what we believe is a very flawed and a false theory. They went to a judge of the court and they said, we need a warrant naming her, Karen Reed, and they seized her phones. And today, in this moment, the special prosecutor is actively litigating to keep her phone away from her, out of her possession. So in terms of
So in the context of the case against Turtle Boy, Karen Reed was not indicted in that case. So while they might have had grounds for a search warrant at some point, we know that there's been ongoing issues with them trying to get back Karen Reed's property. If they are talking about the physical cell phones, why haven't they been returned? She's not been charged. If they extracted the phones, then why haven't you turned over given back the physical phones? Which, depending on when these phones are from, those phones might actually be relevant to her defense in her civil cases. If these are the phones from the time period covering John O'Keefe's death and the aftermath of John O'Keefe's death. We talked about the fight over Karen Reed getting her property back at least a year ago. And they still haven't returned them. Okay. I remember this. Patty in the chat said they were refused a search warrant to search the contents of the phones. I remember that. We went over it ages ago that they had possession of the phones because it's two different things, seizing the property and searching the property. And that was my remembering as well, that they did not get a search warrant to be able to search the property, which means even if they're extracted, the phones have to go back to her. And if they can't look at the extractions, then they can't look at the extractions. And if they're not allowed to extract them, then they can't extract them and they have to go back to her. Okay.
When the Commonwealth stands up and says Karen Reed is basically a stranger to this conflict, she has no standing, this is Aidan Carney's conflict, that's simply not true. I've asked the court to inquire a few questions of Mr.
So Jackson's addressing the argument that Karen Reed doesn't have standing. We have seen this argument come up in a lot of these cases because there's so much that's overlapping. But if the search warrant, you have to generally have some type of case or controversy to get a search warrant. So the search warrant is pertaining to her, though, even though this criminal case is not as to her. So it is her property. She has the right to argue.
Cosgrove. Whose phone is it that's at issue?
Right.
Whose name is on the warrant? Whose privacy is on that device? That's not Karen Reed borrowing Mr. Carney's grievance. That's Karen Reed asserting in the most direct way that she possibly can her own interests that the law recognizes. The interest in her property, which the government seized and is improperly holding.
Right.
The legal standards and why we're here. Let's be clear about what the governing law is at the outset, because the entire Commonwealth's opposition depends on the court and in hopes of the court applying the wrong legal standard, which I'm sure it is not want to do. The right one is in place. When the right one is in place, the entire argument by the Commonwealth falters. The rule for prosecutorial disqualification, and I say that with an emphasis on the word prosecutorial because I'm going to get to a point that Mr. Cosgrove cites in his moving papers that is incorrect citation and incorrect application of the law.
Oh, boy.
The rule for prosecutorial disqualification in this Commonwealth is told to us by a couple of cases that we cited in our moving papers and the court has in front of it, PISA and Ellis. And it's not ambiguous in the least. PISA versus PISA versus Commonwealth
I'm glad he spelled it. I was thinking Pizza. Thank you for clearing it up, Jackson.
Deals with prosecutorial conflicts of interest that are treated with absolute strictness. And the words matter. No showing of prejudice is necessary by Ms. Reed at all. The court does not weigh whether actual harm resulted. It does not weigh whether actual prejudice exists. We don't have to show any of that. The law does not ask whether the conflicted party, in fact, changed any outcome. We don't have to show that. And Ellis completes that rule.
Cosgrove, in this case, is appointed as a special prosecutor. So the reason we are hearing him talk about the special prosecutor, I'm curious, but there was a special prosecutor in this case along with Reed too. I'm super curious.
By saying that a prosecutor's discretionary choices have to be, and this is the important part of that language, completely and utterly unaffected by any private interest in fact or, and this is...
For those of you listening in the background, I'm going to just back this up. I understand that a lot of you are just happy to be following the linear, uninterrupted argument of Alan Jackson. Yes, but the judge just did something that we don't always see the judges do anymore. Turned around behind him and grabbed one of the books to pull the case cite. Love it.
Fact
Love
changed
it.
Any outcome.
I backed it up.
We don't have to show that. And Ellis completes that rule by saying that a prosecutor's discretionary choices have to be, and this is the important part of that language, completely and utterly unaffected by any private interest in fact or, and this is the big whopper, in appearance. It's those two words that I want to focus on for a quick second. In appearance. That phrase is the whole case. The law does not ask whether the special prosecutor, whether Mr. Cosgrove was actually influenced by Mr. Morrissey or anybody else in the Norfolk County District Attorney's Office. It asks, very simply, whether the public, looking at this arrangement, can have utter confidence that he was not in any way influenced by the DA's office. In other words, the law asks a very, very clean question, Judge Doolin, and the answer is very clearly as clean. It is no. The public cannot have that confidence. And I ask the court to just hold that law in the back of its mind for a second as I talk about the next point of the argument, which is the actual indication, the evidence of the breach of that promise. And this is because of the facts of the case. There is a breach because of the facts, and the facts are not very friendly to Mr. Cosgrove's position.
Okay.
And they're also not in dispute because they came right out of the special prosecutor's mouth. On February 19th, from the podium, Attorney Cosgrove told the court that he would basically sit down with the district attorney's office. He was going to go through all of their options. They would weigh the pros and cons of all their options and discuss those pros and cons and then get back to the court in due course.
What?
His actual language is this, and I'll quote him. Quote, "I'd like to take some time to look at Judge Krupp's decision."
If the special prosecutor was appointed because of a conflict, then there is a wall between them and the DA's office. If the special prosecutor was appointed because they didn't have enough resources, it's different. But if the special prosecutor was appointed because of a conflict, then they can't sit down with anyone at the DA's office. Look at the judge's face. The judge's face is causing me concern because what do you mean they're sitting down with the DA's office? Because if there's a conflict, you can't sit down and talk to the DA's office. The judge's face is just like, what? Okay.
And to meet with the district attorney's office, the Norfolk County District Attorney's Office, I intend to do that within a week or so and discuss with them our various options. And we are going to give, are we going to give the cell phone back? Are we going to move for reconsideration? are we going to file a notice of appeal? And when
I wonder if this is why, because at the very beginning of this, and I have not watched this hearing yet, so at the summary at the end, I'm sure it will all make more sense to me, but at the beginning of this, Alan Jackson led with that Cosgrove was arguing that the conflict was as to Aiden Carney, not to Karen Reed. So is the prosecution or the special prosecutor trying to say that sitting down with the DA's office was not improper because they were talking about Reed's subpoena? However, it would seem to me, if this is the witness intimidation case, that the witnesses that are alleged to have been intimidated are the same witnesses on the Karen Reed case, so that line becomes very blurred because the conflict is really going to the witnesses in the middle of it, not as to the defendants in the case. That's why Jackson was saying, oh, this was a clever argument. Interesting. Okay, well, I'm very curious where this goes.
done that, I'll get back to you as soon as possible, end quote. Those personal pronouns and the possessive pronouns used in that
pronoun problems or not pronoun problems, pronoun arguments here, which we've seen Judge M point out so well of like, no, we have problems.
as soon as possible, end quote.
Oh boy.
Those personal pronouns and the possessive pronouns used in that phraseology, in that paragraph, are not of insignificance. Who is the we? Who is our options? Who's the our in those sentences? Obviously, it's in perfect context. It's Mr. Cosgrove, and it's the Norfolk District Attorney's Office. In an unscripted and what I would consider to be a pretty unguarded moment, Mr. Cosgrove betrayed exactly what's going on here and who's really prosecuting this case. And I put prosecuting in quotation marks, but who's advancing or forwarding this case against in terms of the search warrant against Miss Reed. Isn't investigating Miss Reed. They are investigating Miss Reed. He isn't holding her phone. They are holding her phone. And he said the quiet part out loud. They're improperly holding the phone together because they're coordinating together. And those are his words, not my words. According to Mr. Cosgrove, he could not and was unwilling to independently make any decision in front of the court what to do about Judge Krupp's very unequivocal order to return Miss Reed's phone unless and until he met with the district attorney's office. He explained on the record what needed to happen before he could make that decision, and I'll just repeat it very quickly. Are we going to give Miss Reed's cell phone back? Well, the unanswered part of that question is, I can't make that decision, Judge, without speaking to the DA's office to find out what they want to do.
Oh boy. Well, the judge's face seems to indicate that he is very much tracking what Alan Jackson is saying, because the arguments that Jackson is making, if the behavior that he is relaying is accurate, is a big problem. It's a big problem. Because if you are supposed to have a wall between the prosecutor that is the special prosecutor and the prosecutor's office, it seems that they have jumped the wall. Either that or the wall doesn't exist. It has a door in it, and they're just like, it's fine. We're connected. That's a problem. And the judge is just like, I hear what you're saying. Oh boy. That's a problem.
Willing to independently make any decision in front of the court what to do about Judge Krupp's very unequivocal order to return Miss Reed's phone unless...
And I was so caught, I needed to back that up one more time. The other judge ordered the phones returned? Oh, fantastic. Oh, gosh. Okay. So the phones were ordered returned, And the special prosecutor, who is supposed to be independent, was like, I need to see if the DA's office will agree. That's not how that's supposed to work.
Investigating Miss Reed. They are investigating Miss Reed. He isn't holding her phone.
Back up. I need to hear that
They
again.
are holding her phone. And he said the quiet part out loud. They're improperly holding the phone together because they're coordinating together. And those are his words, not my words.
Oh, boy.
According to Mr. Cosgrove, he could not and was unwilling to independently make any decision in front of the court what to do about Judge Krupp's very unequivocal order to return Miss Reed's phone.
That's not good.
Unless and until he met with the district attorney's office. He explained on the record what needed to happen before he could make that decision. And I'll just repeat it very quickly. Are we going to give Miss Reed's cell phone back? Well, the unanswered part of that question is, I can't make that decision, Judge, without speaking to the DA's office to find out what they want to do. Number two, are we going to move for reconsideration? Who's we? Him and the district attorney's office. That's who he was referring to. The unspoken answer to that question is, I don't know. I got to check with the DA. The third question he posed, are we going to file a notice of appeal? Again, the unspoken answer was, I can't decide that, Judge, not today, because I...
Hold on. I have to. The opportunity is too ripe. The opportunity is way too ripe. Wait, where is it?
Not today, Judge.
So you're telling me that the court ordered the phones returned and the independent special prosecutor was trying to figure out if the DA's office wanted to file for reconsideration or appeal? It's not their choice. It's up to the special prosecutor. Oh, boy.
I need to first sit down with the DA's office and figure out what our various options are.
No.
It couldn't be any clearer. This is with the completely walled off Norfolk District Attorney's Office, the conflicted office, the office headed by an alleged, a self-described victim of Miss Reed, Mr. Michael Morrissey. He was the authority Mr. Cosgrove admitted he needed.
There's the conflict. How? You're all just going to say because Massachusetts, Emily, keep reading. How? If you're the special prosecutor because of conflict, you can't talk to anyone at the prosecutor's office. That's the point, is that you can't talk to them.
Was headed by an alleged, a self-described victim of Miss Reed, Mr. Michael Morrissey. He was the authority Mr. Cosgrove admitted he needed to go to before he could make any other decisions. And there's no other way to read his words. The fact is, he was not authorized, obviously not authorized to make any strategic decision about Miss Reed and her phones until he got prior approval from the very office that was the subject of the conflict, and that's the problem. It's not a good look for the DA's office. It's not a good look for the Commonwealth. It's not a good...
Beyond it's not a good look. That's not how any of this works. That's not how it works. That's not how it works. I imagine the judge is looking at the motion that's filed by Attorney Jackson while listening to his arguments. But that's not how this works.
Good look for Mr. Cosgrove. And appearance, when I use those words guardedly, it's not a good look because appearance means everything in this case, as we'll see.
Because appearance of impropriety is a standard in a lot of the case law. You don't have to prove impropriety. It's the appearance of impropriety. If you are a special prosecutor because of a conflict, you don't get to go chat with the conflicted office.
So Mr. Cosgrove, in his moving papers, he sees the problem, obviously. He's a very intelligent gentleman, a very good lawyer, he sees the problem in the accidental admission, and so he tries for an escape route. His claim now is, no, I was just notifying, I was indicating that I would notify the DA's office about what I intended to do. Except, Judge, that's not what he said. He said, I can't decide until I meet with them and we discuss our various options. That doesn't sound like informing anybody of anything. Certainly doesn't sound like informing anybody of a decision that's already been made. I think the court would agree with that. Rather, it sounds like a conversation inviting everybody to weigh in. Everybody is invited to the table.
The judge's face is facing. The judge is like, what the fuck? I have the same, what the fuck? What the fuck is what the fuck is happening? I agree with the court's face. Correct, Your Honor. What? What are we doing? This is insane.
It doesn't sound like informing anybody of a decision that's already been made. I think the court would agree with that. Rather, it sounds like a conversation inviting everybody to weigh in. Everybody is invited to the table. Let's talk about strategy. Then, Judge, I'll get back to you. Mr. Cosgrove actually showed us what's really going on behind the closed doors that we suspected all along. So who's really
in charge
advancing this case? Maya Angelou once said, when someone shows you who they really are, believe them the first time.
I mean, I guess it's not Hamilton. We're never mad at a Maya Angelou quote, but at this point, we're just expecting things to go back to the revolution.
Advancing this case. Maya Angelou once said, when someone shows you who they really are, believe them the first time. That is a poignant and pointed statement that I refer the court to just to say, if someone says something in an unguarded moment, you got to sort of put some stock into it. You got to believe them.
What are you looking to disqualify Mr. Cosgrove from? Any involvement in the Reed cell phone issue?
Yes.
Or also, I mean, do you believe that you have standing in the case of Commonwealth versus Adam Carney?
I don't think he can ask to disqualify him off of the Carney case, but he can ask him to be disqualified off of any further argument regarding Karen Reed's cell phone. I think he can ask that somebody else get appointed. Shouldn't God, we're back in a bricks and minifigs issue. Just give back the fucking phone. Why are we still fighting over that? Just get back the phone. Just get back the Lego. Get back the phone.
Disqualify Mr. Cosgrove from any involvement in the Reed cell phone issue?
Yes.
Or also, I mean, do you believe that you have standing in the case of Commonwealth versus Adam Carney?
So that's a very good question. I wrote in my notes. The judge is going to ask you, what do you want me to disqualify from?
That was pretty good.
That is the question. It really is, Judge. Yes. In answer to your question pointedly, he should not, Mr. Cosgrove, and like I said, seems like a kind gentleman, very good lawyer, but he cannot advance the case having anything to do with Karen Reed. Why? Because the investigation, as it is, for whatever that investigation is, the only insight I have, the only crystal ball I can rub, has something to do with this search warrant. So He should have nothing to do with advancing the search warrant. He should be removed altogether because the DA's office is removed altogether. And if, in fact, to answer
the DA's office is removed, he is now essentially tainted by having these intermingled conversations with the DA's office, which creates a further conflict as to Karen Reed.
The next question the court might have, if in fact there's another special prosecutor that were to be assigned to this case, God forbid, to complicate matters more, that person should have no communication, no contact with Mr. Cosgrove, nor the Norfolk County District Attorney's Office.
And who should appoint that person?
That's the $64,000 question, Judge.
We'll make the court do it. Because generally special prosecutors are appointed by the District Attorney's Office. Again, can we get a discovery referee? Nah? The judge is like, and who does that? We are in kind of a quagmire, right?
I don't believe that person can be appointed. I believe that this has run its course and that the district attorney's office was supposed to do what it wished to do by hiring an independent special prosecutor. Unfortunately, that independence was magnificently breached, not in a small way, in a big way, in the biggest of ways. And so I think the district attorney's office is not in a position to say, okay, well, I'll do it again. I'll take a mulligan on the first one, and I'll do it again and appoint a second special prosecutor. That search warrant should be dead on arrival because Judge Krupp said the phone has to be returned. The only reason that Mr. Cosgrove is even following this thread, pulling this thread, is in no small part. As a matter of fact, I would say it's in almost total part because the Norfolk County District Attorney's Office did not want that phone returned.
Return the phone! It doesn't matter if they don't want to return the phone. There are rules and laws. Return the phone.
Okay, let me call upon Mr. Cosgrove.
Of course.
Yeah, Mr. Cosgrove, go right ahead, sir.
Oh, boy. Let's hear what Mr. Cosgrove has to say. Thank you, chat, for no spoilers. I haven't seen this hearing. The court's like, huh?
Well, Your Honor, let me begin where Mr. Jackson began with the discussion of standing. And Mr. Jackson made a wonderful argument that his client has standing to litigate the possession of her telephone. He made a terrific argument that she has standing to challenge the search warrant. But I heard no argument as to what standing she has to raise the alleged conflict of independent counsel, because there is no conflict. Obviously, as I pointed out before, the district attorney just went through 2 trials with Ms. Reed. They were not conducted by a special prosecutor, with the one exception of the special prosecutor for the second trial, Mr. Brennan.
Did you just say they were not tried with the special prosecutor with the exception of the special prosecutor? Are those the words that just happened? Is he trying to say that the special prosecutor was not because of a conflict? Like it wasn't conflict counsel? Because I don't know why Brennan was appointed. I don't know if Brennan was appointed because of a conflict or if Brennan was appointed because the rest of the DA's office was like, fuck this, I'm not going to trial again. So 2 trials, no special prosecutors except that one trial with a special prosecutor. So, what a silly argument. I just have to wonder if he really does mean the reason there was a special prosecutor is not for a conflict purpose, but the argument is worded quite wildly because it's different than a conflict where the DA's office cannot be connected to the case. But still, what an odd thing.
Obviously, as I pointed out before, the district attorney just went through 2 trials with Ms. Reed. They were not conducted by a special prosecutor, with the one exception of the special prosecutor for the second trial, Mr. Brennan, who worked hand in glove with the personnel from the DA's office. So it seems to me, Your Honor,
I think he's trying to make the argument that there was no conflict. But yes, there's different reasons special prosecutors can be appointed. Remember, Carrie Morrissey was appointed as a special prosecutor in the Baldwin case, and the prosecutor's office at that time said that they weren't staffed enough to have somebody on that case, and they just didn't have enough people, so they needed another attorney. A special prosecutor due to a conflict is a much different circumstance. I don't think you can argue that because a special prosecutor in the Reed case wasn't there because of a conflict, that means that in this case it's the same. I don't think that tracks. because this is a totally different case with different facts and different witnesses. I'm curious to see where this goes.
That Ms. Reed has no standing because there is no conflict. Even if I were consulting with the DA's office on my every move, which I am not, I don't see that there would be a problem.
Okay.
I have yet to hear what Mr. Morrissey's personal interest or conflict is in this case. It was represented in the papers that were filed that he was a victim, and I heard Mr. Jackson describe him as a self-described victim. I can use the word described twice in one sentence.
So is the argument here that the conflict of the DA's office is because District Attorney Morrissey feels personally victimized by Regina George? Is that where we're at? All right, keep reading.
I don't know when or where or if he actually made that statement or what the context was, but certainly there has been no indictment that I am aware of or charge or whatever listing Mr. Morrissey as a victim in any way of this case.
Okay, so why were you appointed then? Then, like, why are we here? Why are you here? Somebody should know this. Chad, I'm not asking. Chat, thank you if you do know. I'm not asking for spoilers. I am simply rhetorically stating this is something that should not be confusion.
As I listen to Mr. Jackson recharacterize my comments, I can't make that decision. I can't decide that. They do seem quite damning. The only problem is those aren't the comments that I made. I made the comments that I made. They're a matter of record. They were quoted in the initial filing. They were quoted in my filing.
So what did you
submitted
say?
An affidavit explaining what actually happened. Credibility of that affidavit is, of course, for your honor, and I'm not going to argue it.
And? Wait, it didn't freeze.
I will only...
To everyone listening in the background, I'm so sorry. He has embodied pause. I'm not frozen, you're not frozen, we're not frozen. It's Cosgrove is just pausing a bit beyond the normal spacing of sentences. So I also think he's buffering. It's not, it's him.
Say about Pisa and Ellis that if your honor looks at the facts of those two cases, they are totally divorced from anything that's before your honor today.
What was the issue with Ellis? I just read Pisa when Mr. Jackson quoted it. What was the issue on Ellis, the recusal?
If I remember it correctly, your honor, it's been a while since I've read it. It had to do with some illegal behavior by police officers that the district attorney was involved with. But I apologize for not being more on top of it.
Chat. He is talking about the case law. So if you're just like, if your ears just perked up in the background and you're like, what about the DA's office being in on it? He's talking about the case law that they're citing. These are the underlying facts of the case law that they're citing.
But I will take a look at it, and if you wish, files.
I'll read the case, but I was just curious.
Also, as a matter of practical course, when you are opposing a motion, read the cases that opposing counsel cited. We didn't become lawyers because we don't read. All we do is read. We read so much. I changed prescriptions like 3 times in law school. We read so much. read the cases. You don't think the court's going to ask you about them? And hell, you can even get them summarized by like Notebook LM. Like, it's gotten so much easier. Just read the cases. Even the cases have summaries.
Why is no one ready?
I do want to comment on Mr. Jackson's response to Your Honor's question.
Also, I'm not done ranting. Look, in 2026, it is, I think, incumbent on all attorneys and judges, but all attorneys, to check the citations of opposing counsel to make sure that they are real. I can't imagine being involved in motion practice and not checking every single case citation to make sure that they are a real case, that they are accurately cited, and that they stand for the proposition that counsel says they stand for. I think it is actually more necessary now than it was 10 years ago, 5 years ago. Okay. Bluebell said, remember the lawyers that used AI in their papers? It's happening all the time. It's happening all the time. It's happening all the time. So anyway, yeah, I think you have to read what opposing counsel cites. And all of these attorneys have access to all of the like Westlaw and LexisNexis. It's not like it's hard. What? Like it's hard? It's not. This is part of your job.
Which he apparently was well prepared for and anticipated. Are you asking me to disqualify Mr. Cosgrove on the Kearney case or just on this matter? And I think the correct answer, Your Honor, is it really doesn't make any difference, because if Your Honor finds that I have an ethical conflict of interest and can't serve in this case, I think that counsel for Mr. Kearney will be in court tomorrow morning, waiving your decision.
That's probably
saying
true.
the Commonwealth has had a full and fair chance to argue the situation, and it should be applied res judicata. So I think that's going to be the bottom line, one way or the other.
I can see that that's. I can see that would probably happen. But I can also see them saying they have an opportunity to be heard elsewhere. I mean, but res judicata is in fact like a thing. Like if the judge made that order, then it kind of holds. And if you are in fact special counsel because of a conflict and you are having conversations about evidence in this case with the DA's office, then you've breached containment. So that's not wrong.
Finally, Your Honor, I'd like to comment on the credibility of the other side in this case.
No, why?
My attention was...
Why?
Was recently given to a video recording of the March 18th, 2025 second trial of Karen Reed. And I observed the video.
Why?
On the internet. Therein, a justice of this court made the following oral findings, and I'm going to quote them.
What are we doing? Your Honor, I watched a video on the internet from March 18th, 2025, where a judge made the following finding. I bet I can guess what's coming next, where the judge was very upset with counsel for misrepresenting things to the court. Right? Let's see. But why are we doing that?
On the internet,
He watched on the internet.
therein a justice of this court made the following oral findings, and I'm going to quote them, and I'll submit an affidavit upon the completion of doing so because I'm...
Why didn't you submit this before the hearing? Also, why don't you just submit a thumb drive with the hearing then? Or better yet, if you want to make this argument that the court shouldn't listen to counsel, why don't you order the transcript before the hearing?
I'm going to skip over a lot of factual details that aren't particularly relevant here.
Okay.
In open court, Judge Cannoni said, based on all the evidence, I conclude that the candor required by all lawyers has not been demonstrated here. I find there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate. They were made in sidebar, in open court, and in pleadings. And after going through some of the details, she says, I find that there was a material misrepresentation and that it was...
Did you put this in your pleadings or are you just trying to spring it up here? Because the judge is like, what the fuck are we doing? I don't think this was in his pleadings. I think he just wanted to throw it back out there and be like, Your Honor, you shouldn't listen to defense counsel. I don't know if this is, if you're not going to put this in pleadings, this is kind of a mess.
Deliberate. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. Those comments were made with respect
counsel
to Mr. Jackson and the colleagues from his firm
and
who filed the motion and affidavit and did the oral argument before the court today.
Jackson didn't do the oral argument in that motion, though.
And I would ask the court to consider that finding with respect to the credibility of the defense finding.
Wow.
And I will close with the words of Mr. Jackson. When someone shows you who they are, believe them the first time.
Okay, counsel. Did you put that in any of your motions? Because that kind of goes beyond argument if it's not in your motions. But sure.
I'll submit this to the court, and I have a copy. Thank you.
So you didn't put in your filings. That's yeah,
Sure.
I'm sure Attorney Jackson is like, I would like to be heard. Yeah, I'm sure. A bold strategy, counsel. Okay. I'm curious to see how this goes. Why? What did Jackson represent to the court other than the things that you said in a hearing? It seems like it just seems kind of out of left field. But sure.
Yeah, just grab me the book. All right. Mr. Jackson, I take it by the fact that you've risen that you wish to respond to something.
The judge is like, I take it you would like to be heard. Yep.
I would like very briefly to speak to a couple of issues.
You can see how seriously the court is taking these statements that have been levied at Alan Jackson. The court looks like he has taken this quite seriously. Does he not? The court's demeanor kind of tells you everything. I don't know if this is a door you want to open, counsel. This might be an unforced error.
All right. Mr. Jackson, I take it by the fact that you've risen that you wish to respond to something.
I would like very briefly to speak to a couple of issues. I find it rich that a member of the bar who doesn't like what his own facts represent decides to take a personal shot at opposing counsel. That's, I think that's beneath Mr. Cosgrove's dignity. It's certainly beneath the court's dignity. The court doesn't have any idea, because it wasn't sitting in the courtroom along with Judge Cannoni, what the circumstances of those comments were.
There's been no transcript submitted. If this was of such grave concern to Cosgrove, pull the transcripts and submit them. But Jackson's like, Your Honor, can we just all call this bullshit? Because it's some bullshit. Oh boy.
At opposing counsel. That's, I think that's beneath Mr. Cosgrove's dignity. It's certainly beneath the court's dignity. The court doesn't have any idea, because it wasn't sitting in the courtroom along with Judge Cannoni, what the circumstances of those comments were. And certainly Mr. Cosgrove has absolutely equally no idea what those comments were. And it's offensive, but it also is very telling. It's extraordinarily transparent.
Your Honor, when you can't attack the facts, right? Just attack the person, bang the podium. Right. He has no argument, Your Honor, so he's going to argue that I suck. Mm-hmm.
If you don't have the facts on your side, then you argue the law. If you don't have the law on your side, then you argue the facts. And if you don't have the law on your side or the facts on your side, just attack opposing counsel.
I thought you were supposed to bang the table.
I think so.
You're supposed to bang the podium. Exactly. And if neither are on your side, bang the podium. We all know this. All of us know this. This is exactly what it is. I like that this judge is giving it the solemnity that it requires. Right? The judge has clocked exactly what this argument is and is not, the judge does not seem deeply persuaded. To bang the podium. A number of you have said the Donna Adelson strategy. Yeah, is exactly what her lawyer did. It's exactly what we got from Donna Adelson's lawyer, was bang the podium.
When you argue the facts, and if you don't have the law on your side or the facts on your side, just attack opposing counsel.
I thought you were supposed to bang the table.
I think so. Exactly. That was good. Try to make it as loud as you can.
Bang the podium.
That was the old saying, anyway.
Yes, exactly. And I think everybody in the courtroom can see that. It's a little bit of an act of desperation. And I appreciate the cleverness and the desperation that Mr. Cosgrove shows, but it is of no legal moment for why we're here today. So no, to answer the court, once again, I am not suggesting I take no position on Mr. Cosgrove's further investigation or prosecution as it relates to Aiden Carney. That is not my position. He is not my client.
At some point, I'm going to have to figure out where that age-old adage came from. But yes, bang the podium. The judge is just like, right, we know what this is.
But what I am concerned with is his position in terms of the search warrant and any further investigation into Karen Reed. And I find it
that's fair.
Almost nearly shocking, if I can use that word,
no,
that Mr. Cosgrove...
You cannot. We have a new word now. Breathtaking. It's breathtaking in its desperation.
...would stand up and say, there's no conflict.
Go right ahead.
Even were I to consistently consult with the Norfolk County District Attorney's Office, that would represent no harm. There's no big deal. Your Honor, if it was no big deal,
NBD, Your Honor,
that he consult with the conflicted Norfolk County District Attorney's Office
then why
over the issues attendant to witness intimidation that is focused on Aiden Carney and concomitantly focused on Karen Reed, because
10 out of 10 use of concomitant. 10 out of 10. Jackson really does whip out the vocabulary at the best times. It is a 10 out of 10 use of concomitant. Look, Emily, do we like this concomitant or do we like Shank of the Evening? Shank of the Evening was new to me. So there's a delight delightfulness and the novelty, but the fluidity of throwing concomitant in here was just a 10. Just a 10. And he's refrained from saying, Your Honor, everything that guy just said was bullshit, which is also commendable.
If it was no big deal that he consult with the conflicted Norfolk County District Attorney's Office over the issues attendant to witness intimidation that is focused on Aiden Carney and concomitantly focused on Karen Reed because of what he says may have been an agreement between and among them, then the question is begged, why was he ever appointed in the first place?
That's a great question.
If there's no issue with conflict, why was he appointed? Why is he getting paid taxpayer dollars? He was appointed because Mr. Morrissey recognized that there was a potential conflict because Mr. Morrissey is a titular victim, a potential victim of the very allegations he's investigating. And now Mr. Cosgrove is proverbially in bed and has been with the district attorney's office. That's the issue that we've got. And Mr. Cosgrove's affidavit.
Right. The argument is that if they are appointed because of a conflict and you have now had conversation with the district attorney's office, anyone from the district attorney's office, it taints counsel with conflict. And then you need a new one. Right. Right. In the chat, Norton Cancellation said, wait, Cosgrove is getting paid for this. Oh yeah, no. When there is a special prosecutor appointed, they are paid out of the district attorney's budget unless additional budget is given to them for them. Yes, they are getting paid by the taxpayers in addition to whatever all the other district attorneys are getting paid. So this would go generally on top of whatever the DA's office is already paying. Yeah. So the taxpayers are paying more. Yep.
Is equally flawed as his reasoning on that argument. His affidavit does not cure the problem. His affidavit is the problem. Consider what it actually offers. It's a sworn assurance from the very person whose assurance of independence is in question by his own words. The court doesn't have to find, and I'm going to step up a little bit from the personal attacks and invectives. I don't think they're appropriate in the courtroom, and I'm not going to lower myself to engaging in those. The court doesn't have to find, at the end of the day, that there was actual prejudice or that there is actual prejudice against Ms. Reed or her interests. The court does not have to find that there's actual bad faith on the part of Mr. Cosgrove. Neither does the court, or neither does...
However, the arguments he was making in court are kind of giving bad faith, aren't they? But Jackson has turned it back around to, I am not stooping to this level. I'm not going to roll around in the mud with this. I'm going to remind the court that the standard the court needs to consider is this. And so he's bringing it back to the legal argument while saying, this is beneath me. So I do not deign to respond to this argument that's beneath me. While also reminding the attorney that, like, you could never be me. That's why you're so mad. So, continuing on, he's bringing it back to the standard.
The law required that the court find that anyone lied or anybody was mendacious. I'm not suggesting that. And the court doesn't have to...
We also got almost to mendacity? It was so close to mendacity. The court does not have to find that anyone was mendacious. God, we love it. Love it. The mendacity of it all. There we go. Ah, the vocab.
That there's actual bad faith on the part of Mr. Cosgrove. Neither does the court, or neither does the law, require that the court find that anyone lied or anybody was mendacious. I'm not suggesting that. And the court doesn't have to find it. Or that he, in fact, made any decision that was on its face corrupt or conflicted. The court doesn't have to find any of that. The law is very clear, Judge, and that's why we're standing before you. It requires one thing. It requires independence in fact and in appearance, and that has been breached. By his own words,
Jackson stepped back and said to the court, your finding does not have to be extreme. It is whether or not the kind of appearance or actuality of intermingling between the conflicted parties that are supposed to be separated like completely by a wall. You're not supposed to have any communication back and forth at all. So if there is the even appearance of that, then it's a problem. So he also gives the court a way to say, I am not finding bad faith. You don't have to find that Cosgrove is lying, but you can find that the appearance is that this independent prosecutor is not in fact independent and therefore should not even be making those arguments. However, why can't we just get back the phones?
the special prosecutor, Mr. Cosgrove, has indicated that the appearance of independence is gone. And for those reasons, the only remedy as it pertains to Ms. Reed's interests is to disqualify him from any further contact or connection with the search warrant and any investigation related to witness intimidation.
Okay.
Thank you.
Thank you very much. Thank you all for being here. I'll take it under advisement.
Thank you, Your Honor.
Thank you.
Appreciate the time.
Thank you, Your Honor. I'll go on.
Wow.
I think that's it.
All right. And that brings us to the end of that hearing. I am going to add this to the docket because I am very, very curious. This is going to take a little bit of research on my end, but I am very curious to see what the court does at the end of this hearing, because the fact that Karen Reed, so at the end of this hearing, where are we? We took a look at the July 13th, 2026 hearing regarding the search warrant for Karen Reed's cell phones, the fact that another judge has ordered Karen Reed be given back her cell phones, that the cell phones haven't been given back. And now the argument from attorney Alan Jackson is that the special prosecutor, he is arguing, was appointed because of conflict at the Norfolk District Attorney's Office with this witness intimidation case, that the special prosecutor, as to Karen Reed's cell phone, the search warrants and all of that, should no longer be the one handling anything to do with Karen Reed's phone, the search warrant, etc., because that special prosecutor has, as Jackson argues it, by his own words, said that he is having communication and going a step further than having communication with the Norfolk District Attorney's Office, but saying, I can't make those decisions on my own. I need to run it by the Norfolk District Attorney's Office, which means then they are not, in fact, an independent special prosecutor. And the special prosecutor argued, one, don't believe what Alan Jackson said because this is what Judge Cannoni said about him or the Reed defense attorneys. Two, even if there was a conflict, and I'm not saying that there is, it's not as to Karen Reed because this prosecution is to Aidan Carney. And three, I'm allowed to talk to the Norfolk DA's office. And four, I'm not asking them for their blessing on what I do. Surely I am not always asking them what I should do. He did not say he is completely independent and he's never spoken to them. So I'm going to need to do a little bit more of a deep dive into WTF is going on with this, because I remember when we heard in not only Judge Cannoni, who said there's no reason to continue to hold Karen Reed's property as to Karen Reed's criminal case with Judge Cannoni, but then we also hear that the judge in the Turtle Boy witness intimidation case also said you have to give her back her phones. So they're not being held because of her criminal prosecution, which is done. She was acquitted. And they're not being held as to the investigation into the witness intimidation because she was never indicted, even though they asked for that and they didn't get one. And that investigation as to her is over. So on both criminal cases, her property's been ordered returned. So give it back. And I wonder what's going to happen with either disqualifying Cosgrove if they are continuing to fight not giving the phones back. Which begs the question, why are there still fights over this? Why are they still fighting this? So, I guess we will see. Leonard in the chat asked, EDB, what if they don't have her phones? Then that is a huge problem if they don't have her phones. That is a big problem if they don't still have her phones. And then, well, I imagine there will be another lawsuit over that. Scorpio said, EDB, they are trying to indict her again. Too bad. They can try to indict her. The court has ordered it back. You have to give her the property back. And then if they indict her, they can go get it again. You don't get to hold on to things indefinitely. It goes beyond the powers of government. And so the fight over this is a problem because it should just be turned over. It should just be given back. And I don't want to is not a sufficient legal grounds to not turn it back over. And it's not the first time we've even seen this argument. Remember when we were watching, I don't remember which hearing date it was, but we were watching the hearing with Canton about Canton turning over discovery. And this is when we started really talking about Pretty v. Please, because the Canton attorney was saying, yes, Your Honor, we know we have to turn over that discovery. We just don't want to do it yet. Huh? What do you mean you just don't want to do it yet? Well, we still have an ongoing investigation going on with regard to not so good, so we just don't want to do it yet. Oh, excuse me, that was me. So, Your Honor, it would be really helpful if we could just have a little bit more time. No, you need to turn it over. Just turn it over. And they were like, yeah, it would sure be great if we could just do this later. Huh? You don't get to just do it later. So it's going to be wild. Heather McGovern asked in the chat, what's with all the deleting comments? They're getting caught by Nightbot. So there are too many caps and too many emojis. So they're getting caught by Nightbot. Because that's what Nightbot does. Is when there are too many emojis or too many all caps, it grabs them. So it's Nightbot. Don't run afoul of Nightbot and it'll be fine. But I can see all the moderation actions on my end, and what I'm seeing is Nightbot. So that's it. Unless you need to refresh your chat, because I have seen chat issues where YouTube chat just disappears. Because I'm only seeing a few things with Nightbot. It might also be a chat issue. So go ahead and just restart chat, because that has been happening off and on with YouTube chat, where on the user end, it just looks like it disappears. So, but yeah, Nightbot is just being Nightbot. But also chat disappearing. Oh, a lot of you are saying that chat's disappearing when you type something. That's on YouTube end. Refresh your chat. That's not, nobody's deleting those comments. That is on YouTube's end. There's been off and on issues with YouTube chat for a couple of months now. It's been frustrating. So nothing's getting deleted. It is truly just, yeah, all of you are saying that that's happening on your end. Yeah, that's been happening off and on for 2 months. Yeah, that's been an ongoing problem. So just refresh the chat. All right. So where are we on summary? Because EDB has got to go. Where are we on summary? At the end of the hearing regarding Karen Reed's phone and regarding the special prosecutor, the court is taking it under advisement. The special prosecutor is saying, even if I were having conversations with the district attorney's office, it's not a problem. Karen Reed's attorney, Alan Jackson, is arguing, if you are an independent prosecutor, because of a conflict, you can't have any communication, any at all, period, any, with the district attorney's office. So you asking the district attorney's office, are we going to ask for a motion to reconsider? Are we going to appeal this? What are we going to do? That is consulting with the district attorney's office, and that breaches that independence. And that is the problem. And Karen Reed's attorneys are saying, and we think that Cosgrove should no longer be able to handle anything going on with the search warrants with regard to Karen Reed. And I'm going to need to go pull all the motions, because how in the world are we here when there's been court orders to turn over the phones and this is still being fought over? So I'm going to keep an eye on it. It's going to take me a minute because we still have to get to all of the motions to dismiss and the civil stuff. But this is on the docket. I'm really curious to see what happens here, because there are so many moving pieces, and I don't know if we've covered a case with this many moving pieces. It is truly quite a lot. And we're going to have to wait and see, unfortunately. But wow, there's a lot of moving pieces. And taking cheap shots at opposing counsel isn't really going to go very far, it seems, with this court, because the judge was just like, okay, counsel, have your moment. But they, it's interesting to me that we're seeing this happen across a couple different courts. And it seems to me that the vibes are that this is a jurisdiction that is unfriendly to out of jurisdiction attorneys. And that doesn't surprise me. The East Coast, West Coast beef runs deep, it seems, and includes the attorneys. And that's not uncommon, because I've seen it on the West Coast too, when attorneys come from the East Coast. And the West Coast attorneys are just like, I don't give a shit how they do it in New York. It's kind of the same thing going on here. Yeah, well, that might be how you do it in California. That's not how we do it in Massachusetts. There's this weird tension. And we see it also with like big city lawyers versus not. We saw some of that happening with Carrie Morrissey and some of the filings that we saw with, like, you know, these big city lawyers and the fancy lawyers. Interesting stuff. But you can see a little bit of that underlying some of these arguments as well. SDJ in the chat said, oh my God, I just realized I was on a jury in front of this judge 2 years ago. It seems like the judge was lovely. Hopefully the judge was lovely when you were on a jury with them, because it seems great. Hugh Jeff said, Jackson quoting Rubber v. Glue. That's basically where we got to. Jackson was like, oh, okay. Okay. Thank you. I'm going to we're going to get to questions real quick. And we're going to speed run those because then EDB has got to go. Law nerds, let's chat just real quick. Thank you for being here. Thank you for being a law nerd. Don't forget to check out our sponsor, Incogni. It is in the description below. This case is like sprinting away from me, as I am also just very engrossed in Band Mom life. So it is like, there is so much going on. I wish we had more time this week. We're going to have more time for band stuff, but I do not have nearly enough time this week for the amount of filing. So it's going to take a while to get to the rulings on all of the motions to dismiss. So I think we are good getting to those when we get to those. Unfortunately, it's not today. We are just crunched for time. Night You, it's good to see you. Night You said, us lurkers will ride at dawn for you because you are a rare beacon in this murky world. This community regularly inspires me. This community gives me hope. Look, it reminds me so much when we were here with the Law Nerds that just getting to have a chat from a place of genuine interest and understanding and wanting to connect and understand one another versus wanting to, like, as Ash said in the chat earlier, wanting to just reply, that we are losing a little bit of that seeking to understand in broader context and more seeking to just respond. And I think it's one of the things that frustrates me so much about what we've watched with Judge G is there is so much of just rapid response and no seeking to understand. And I think the Law Nerds do a great job of pushing pause so we can seek to understand and not just fill in the gaps with speculation. It's uncomfortable sometimes to have to wait to try to understand, and it doesn't always fill the immediacy. It's uncomfortable sometimes to not know the answers, to not have a response. But we're humans. We need time to process things. And I think that Judge M did a great job of illustrating that it's okay sometimes to say, pause, let me make sure I understand. And really seeking that understanding beyond seeking response. And I think we're all better for it, that we get to have those moments to try to understand each other. And in chat, you guys do such a great job with this, because it can be hard in text to seek understanding. And so I appreciate that you guys do seek to understand each other, even in chat where sometimes context can get lost and it can be hard to understand. Y'all ask each other questions instead of jumping to one reading or another of something. And it's fantastic. This chat is bae. It's why you see people when they're having a hard time, and we all do. Again, we are humans, unfortunately. Life can be very hard. But we see so many of the law nerds saying, I'm so thankful to be with this community because this thing going on in my life is really hard. And so I want to be here. And I love that this becomes a place for connection, to have some laughs, and to know that for a little bit of time, you can just be like, oh, I'm with the law nerds. You've got me. And we do. It's fantastic. And it's not lost on me. It's incredibly special. Casey Cat, I can't wait to hear more about it. Chaos Law Nerds United at DCI Monday night. I hope it was amazing. I hope the shows were amazing. Let me know what your favorite show is that you guys saw live on Monday night. If you were there, I can't wait. I have not seen nearly enough of the shows live. I've seen them streamed on Flow Marching. Of course, we have our discount link below if you want to stream those on Flow as well. And I will share with you some of my favorite moments from some of the shows. But I've not seen enough shows live because, while I like seeing my kid in the lot, hence the mosquito bites, and then seeing them perform, but then after they perform, then they go back to the lot. And so then I follow my kiddo. So I have not seen enough live. I'm going to get a little bit of time to hopefully do that in San Antonio, but we'll see. Matt Bond, good to see you in the chat. Hello, Spiffy Legal Mumbo Jumbo Talkie Sister from another Mister, and ye Spiffy Legal Mumbo Jumbo Talkie Law Nerds. It's good to see you in the chat. Let's see. I'm going to try to get to some questions to everyone who gifted memberships. Thank you so much to all of our new Law Nerds. Welcome. There are all of the past members only live streams up on the channel. Go take a look at them. They are there for you. Let's see. The Hitchbot said, my favorite part about all of that is Taco Bell announcing that they have reduced menu to fight it. Taco Bell suddenly cares about your intestinal fortitude. Yeah, exactly. Taco Bell's like, we don't want you blaming us. We don't want you to blame us. Taco Bell's like, do not blame us. Do not blame us. Which is fantastic. For all of you that are talking about band, does anyone know what Phantom Regiment's props are? Can somebody explain to me? I don't quite get it. I need someone to explain. I don't know. I don't know what they are. I need you all to tell me. Thank you. Please and thank you. I don't quite get them yet. Let's see. The judge is going full Vader. I've altered the deal. Pray I don't alter it further. It's so frustrating. I don't like it. We've talked about it. I've ranted about it. Consult the Magic 8-Ball before filing. Yes, everyone apparently now needs a Mystic Pickle. A lot of you are saying they're daggers or blades. Okay, daggers. I was like, are they needles? What are... I needed understanding. Daggers make sense because it's bloodline. Lolly said, is that bloodline? I thought they were syringes. It is bloodline, and I wasn't quite sure. All right, daggers make sense. I need someone to do a rundown of the shows and some of the things that are represented within the shows, because sometimes it takes me to the end of the season. I'm like, oh, I get it. I want a little bit more of the behind the scenes of like, this is the show, this is the music, this is the thought behind the show. And I know sometimes that for show designers, like explaining their art is not what they want to do. They're like, no, it's how you interact with it. Can you please tell me if they're needles or not? I don't get it. Thank you. I just want to understand. So some of the shows are easier. Some of them I'm like, explain the props. But as always, I enjoy the music. A horn line and drums are never going to mess with me. So I like it. I like watching the different pre-shows. I love the cheekiness that the Cavaliers have started bringing to their pre-show. Of course, I've watched their show more than anyone else's, so complete bias because it's also my kids' show. But I love seeing all of the little things. Carolina Crown's Doors Are Doors is their show. I understand. It really does let you know what their show is, but also it's in their title, so it's helpful. But I need just a little bit of like an overview, and I think it would make some of the shows more accessible to everyone who might not be as ingrained and nuanced in the world, because sometimes just engaging in anything new can be a little hard. You're like, wait, I don't get it. Right. We just need a little bit. Just a little bit of descriptor would be helpful. All right, let's see. A lot of you are watching World Cup. I hope that it goes well for all of you. I hope that the World Cup happens the way that it should. For you, specifically. Good luck. Let's see. Cat Mom, Leonard, I'm sorry. The loss of a pet is incredibly difficult. I'm so sorry. It is really, really difficult. And it is unique, and it is a very specific type of grief. And I'm sorry. I know we are blessed by our beloved Ponards, and we are blessed when they have a long life with us, but it makes their absence even more stark. I'm sorry to hear it. So I know many of the Leonards have been here and been through that because we love our Ponards, but it is very hard. I get it. Let's see. Samantha H. said, this case has deeply changed my view on the justice system and has really shown just how important transparency in our justice system is. Yeah. There are things that have happened in these cases where I'm like, if somebody tried to explain this to me, I'd be like, no, surely not. And then we're watching it play out. I'm like, this is what? And again, it reminds us how different experiences can be in different courts and how much cameras in the courtroom are a good thing. I have not seen cameras in the courtroom cause more harm than good. And I think when we are seeing courts where we understand what the judge is doing, even if we don't agree, or we see how a case plays out, even if we don't like the parties, we at least have understanding. And when we don't have cameras in the courtroom, we run the risk of not having understanding, not understanding results, and not knowing why certain things are happening. I always think of the Gwyneth Paltrow case in that, because with the Gwyneth Paltrow case, a lot of you went in being like, I mean, I don't really have any love for Gwyneth Paltrow. I have no idea what happened. Why isn't she just paying this dude? And by the time we got to the end of the case, people were like, why is this dude suing her? What's going on? And it allows us to just see how things are happening. And every time there's a stopper in seeing how things are happening, it causes more questions. And it would be nice to have answers. I didn't think when we started covering Karen Read Part 1 that we would get this far down the road and still have this many questions. Like the levels of fuckery that are being just unwrought. And some of that's procedural fuckery. When we saw the hearing with Lally being like, well, I mean, Proctor didn't give me the search warrant. Discovery's ongoing. I guess we'll get it. I'm like, what do you mean? It's just like, meh. And that was just everybody seemed cool with it. And of course the defense attorneys are just like, nah, we're not cool with it. And then we're just like, how is this what's happening? And everybody's just like, discovery's ongoing. What do you even mean? Turn it over. It's been like 5 years. This is insane. But it also reminds us that things that we might experience in one jurisdiction, one court, one courtroom are so far different than what we might see in other courtrooms. And I feel incredibly fortunate to be able to look at all the different courtrooms and overall see a lot of incredible judges and a lot of juries. When we get to the end of the day, I'm like, I see how they got there. And that's the best we can ask for. But really frustrating as we get into some of these courtrooms where we're like, what in the world is going? Amelia said, Emily, do you support cameras in federal courtrooms? All courtrooms should have cameras. Courtrooms should have cameras. Courtrooms should have cameras. I have no problem with some things being redacted from public view as appropriate, but in general, courtrooms should have cameras. And even if the federal court just needed tippy toes, have an audio feed. Why does it need to be so hard to access? The technology exists. What's the problem? Why the hurdles? I don't know. But yeah, I think there should be cameras in the courtrooms. And I think that courts can balance protecting a defendant's rights in criminal, particularly, protecting a victim's rights in criminal, protecting what the rights of our party and public access. It can be a difficult balance, but our system was made for that balance. And I don't think that that balance has gotten harder because people more broadly can get this information. A lot of the cases that we look at when we're talking about media access to courtroom and individual access to courtrooms, a lot of those cases relay back to newspaper and radio. So even though the method of distributing information has changed, I think it is more transparent to just see the judge say the thing versus somebody sitting in the courtroom sees a judge say a thing and then tries to relate to you the meaning, because then it's filtered through at least one person's impression of what was said. And we don't have, and there are some that are the exception, of course, we don't have as much reporting that is just this was said and then the words. A lot of it is the takeaways or the impressions, but then that is still filtering how they've seen something. I would rather us just be able to look at it, because there are plenty of times where I'm like, are they saying this? And chat's like, I think they're saying that. And I'm like, oh yeah, no, I think you're right. Because we've had a conversation. It's why jurors are multiple people deliberating, because the way we hear something and interpret it ourselves might be different than how somebody else interprets it. And that's why juries have discussions on what they took away from something. And when we can all just watch it, then we can see what was said for ourselves, even if it has different meanings. We have the technology. Just let us see what's happening. I also think there should be video in the Supreme Court, not just audio. Why do we just need audio? The courts of our land are here for the people. So trying to put hurdles into people having access to courts doesn't make our system stronger. So I think there should be cameras. I think the difficulty comes in with balancing out fuckery, because fuckery can also be a problem. And high profile cases, I think, have less fuckery if they're not streamed. And that is something that has to be balanced. But I think there's ways to balance that. And with that, Law Nerds, you are the best. It is good to see you. I'm sorry that I will be, well, a little bit more in band land, but we will be back next week. I will be on the app and around the socials to share with you my adventures into Bandland. I have stuff that it didn't even get to share last trip. So I have more stuff coming for you. So if you follow me on Instagram at the Emily D. Baker, I share stuff in Bandland for the next few weeks. If there are case updates that I'm going to share, they will always be in the app. They may also end up on social, but they will always be in the app, lawnardapp at lawnardapp.com. I will be banned things. If you see me when I am out and about, just say, hey, it's good to see you. It's always good to see you. I will be around. And Lawnards, we have much court to come. It is going to come next week. Take care of yourselves. Take care of each other. Thank you for being here. Thank you for being a Lawnard. You are the best. I appreciate you, and I will see you soon. Let's roll the outro. Thank you, Team Baker. I know it's been kind of a choppy week, but it's summer, and I get to see my kiddo. And that is a massive win for me. And Dr. B's feeling better, which means he might be able to travel for finals, which is going to be really good. I'll see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnard.